training and a fraudulent investment.
Court come to order. All rise.
Have a seat, please.
Case 2125, Anderton versus Sorson.
Thank you.
You're welcome.
Ms. Anderton, your case against the defendant is twofold. First, you claim a loan to him in the amount of $10,000. And while he doesn't deny that you gave him $10,000, it is his defense that this was not a loan, but an investment in a project that went south. It went south because somebody conned him, and thus you were conned as well. Somebody took off with the money. The second part of your lawsuit is that Mr. Sorensen is a trainer of some sort, a personal trainer, fitness trainer, and you retained him to put you on some sort of a regimen of both diet and exercise. And you paid him in advance. He wasn't forthcoming with all of the training sessions he was supposed to give you, became unavailable. You want a refund of some of that money. So the first thing I'm going to deal with in your lawsuit is the $10,000 exchange of money. If I find that that, in fact, was a loan or was fraudulently entered into as a result of being duped and being a dope, then I'm going to give you back the money. Then I don't have to get to the training because that's the limit of my jurisdiction. Do you understand?
I understand.
Okay, great. How did you meet him?
I met him on a dating site, actually.
When?
Early June 2021.
Did you date?
We befriended each other. And after our first meeting, that is when I had just come off of a ventilator of 10 days. I was a nurse, contracted COVID. He actually came to my home and said, I could really help you get back to where you were. I needed rehab.
Okay, so after the first meeting, you were not dating?
No.
Is that right, sir?
That's correct.
And that was in June of 2021?
Yes.
When did you, Mr. Sorensen, tell Ms. Anderton about this investment opportunity?
It was about a month into...
So 4 weeks later?
Right.
4 weeks later, you became close enough to discuss with her a business opportunity?
Yes.
And did you discuss this business opportunity with her in her home or over the phone?
In her home.
So I want you to tell me your version of exactly what you told her.
So I had a friend come to me and...
You had a friend whose name is?
His name is Scott.
Scott what?
I can't remember his last name.
I don't believe you.
Okay.
If it's true, then it didn't happen. If it's true that you can't remember his last name, it's because he doesn't exist.
Oh, he does exist.
Oh, sir, you didn't give all that money to somebody whose last name you don't know. I want you to understand that. Then you're looking at me and saying I must have stupid written on my forehead. You don't look like a stupid man.
Absolutely not.
Yeah, you look like you could be a cunning man, but you don't look like a stupid man. So if Scott doesn't have a last name, he didn't exist. I want you to tell me that's in my brain. In my brain is if you can't come up with a first and last name of somebody that you gave thousands of dollars to, he didn't exist.
Okay, in your mind.
Keep going.
I'm not going to keep going and dig any holes. I'm just telling you what the facts are.
No, those aren't facts, sir. That's a fantasy. You know, you're not mentally challenged in any way, are you?
No.
I want to tell you, if I told my 9-year-old grandchild who asked me for $100 because she wanted to invest it with a friend, I would say, what's the friend's name? I don't know. See, I'm not giving you $100 to invest with somebody whose name you don't know, because I'm absolutely positive that if you said that to her, she would have said, well, what's this person's name? I want you to tell me now, Mr. Sorensen, what was the investment?
It was for Happy Pills.
It was for what?
Happy Pills?
Don't look at me.
Happy? Did you say Happy Pills?
Yes.
Okay. Tell me about it. Tell me what you told her. You want to invest in Happy Pills.
Yes.
What she'd say to you? She'd say to you, I'm a nurse, you know, so I'm an educated person. What's wrong with you? Okay, keep going. Keep going. I want to invest in Happy Pills.
Right.
Your friend Scott.
It was a friend of a friend. His name was Scott. Okay, and he introduced me to him and said that, hey, he went...
No, you mean Scott introduced you to somebody else?
No, my friend introduced me to Scott. I didn't know his last name, but we knew that he was in the industry. Okay,
so your friend introduced you to Scott?
Yes.
What's your friend's name?
His name is John. I promise.
Where does he live?
He lives in Salt Lake.
What's his telephone number?
I have no idea what his telephone number is.
Just a second, get out your phone and tell me what your friend's telephone number is. Everybody has their friend's number in their phone.
I don't know what his telephone number is.
Then you see why I don't believe you, sir? Do you understand why I'm having a problem with your story?
It's okay.
Do you understand why I'm having? So a friend whose number you don't
Listen.
have in your phone wanted to introduce you to somebody whose name you don't know to invest in happy pills. And this is what you told her? No, I'm asking you a question. Is this what you told her? I have
Yes,
a friend.
this is what I told her.
John, I have a friend, John, who knows a guy, Scott, who has this company that's going to make happy pills. I just want to know if that's what you're trying to tell me that you told this woman.
I am. It's okay. I don't know why she would make up that story that
No. She's not making up the story. You're making up the story.
Okay.
And if I'm wrong about this, I actually don't feel badly, sir, because then you're the dope that got duped.
And later today,
You devalued her car while you had it.
Yeah, okay.
You used the car for 2.5 years that was running. It stopped running because the engine was blown.
Yes.
And then you stopped making the payments on it.
Yes.
Yeah.
Jennifer Anderton claims her former friend, James Sorensen, owes her for a fake $10,000 investment.
Okay, keep going.
You know what happy pills are?
I assume that they make you happy.
Right. Yeah, they are. It's Molly.
I assume that they make you happy.
Okay.
Right?
Yeah. And so he went around to festivals and he sold Molly there.
He sold what?
Molly.
Molly's.
MDMA. It's an illegal drug.
Oh, okay. So you told her you wanted her to make an investment with you with a big return on your money.
We talked about this for a long time.
Who did?
Me and...
You couldn't have talked about it for a long time, sir. You only knew her 4 weeks.
Okay.
You only knew her 4 weeks. Tell me about this $10,000. Did you take it out of a savings account? Do you have that from the bank?
Yeah, right
I'd
here.
like to take a look at it. You want to tell me, Miss Anderson, the circumstances surrounding you transferring $10,000 to him?
He approached me saying that he needed a hard money loan for his business. He had an e-commerce business with supplements. His father and mother had given him the loans in the past, for the past 5 years, and they've gotten a good return. It was a for sure deal. He goes around and this is their festival project time. They make a lot of money doing this.
What does he do?
For supplements. Like,
So he sells supplements?
Yes.
And it was his business? Mm-hmm.
Yes.
Yes. Did he ever mention a guy, Scott, to you?
No.
It was his business.
Yes.
And he said that his parents had helped him out in the past, had invested with him in the past. So now I understand a little bit better. I see the withdrawal for $10,000. So tell me why he needed a hard money loan.
To buy the product to take to these festivals and
Sell him.
sell them, yes.
Okay.
So he needed it for product.
And when did he tell you that he was going to return this money?
Within a week or two. That it was a week or two of festivals. This was the busy season. He does this every year, and this is a for sure return. And if I did this much amount of money, $5,000, this is how much I'd get back. If I did $10,000, it would be a $15,000 return for me. And I'm like, wow, I could pay off my student loans. I could, yes, do a lot with that.
Okay, so to synthesize what you told me, he told you that this was an investment in his company.
A loan.
A loan for his company for products so that he could go out, sell them for the next several weeks,
Correct.
and you would get a return of 15% on your money.
50%. So a 10.
50? 50? Sounds too good to be true.
Yeah.
Has nothing to do with the company.
The Venmo transfer of $2,000 was to him in June,
June 16th of 21.
and a withdrawal of $8,000.
Same day.
Okay, now, where did you put that money, sir?
I gave it to Scott.
Okay. Okay. I want to tell you, Mr. Sorensen, you have parents who gave you money?
They have in the
Just a
past,
second.
not as you
just
would
say you
say.
have parents
Not in,
that gave you money.
they did not ever give me money for my business ever.
What did they give you money for?
Christmas? They never
I'm
they
not
never
talking-
financed for me for anything in my life. Nothing.
Oh, then you lied
I don't know why she would make up that story that
No,
my parents gave me.
no. She's not making up the story. You're making up the story.
Okay.
And if I'm wrong about this, I actually don't feel badly, sir, because then you're the dope that got duped.
Oh, absolutely. I know. I'm
Then,
dope
just a
that got
second,
duped.
that if you gave
not.
money to John, to Scott, then you're the dope that got duped because they were your friends. That's all I have to tell you.
I understand.
That's all. Judgment for the plaintiff in the amount of $10,000. We're finished. Thank you.
This court is adjourned.
I think it was fair.
I think that was a fair judgment.
We both understood what we were getting into.
No, not until after like 3 or 4 months, and I think he brought that up in fear of me going to the police.
Time to part ways, and definitely learning curves on both ends.
Don't do silly things. It was definitely a learning curve.
I'm glad that things happened the way they did.
Something I'll never do again. And be a little more careful with your money and your investments, and don't trust everybody. I'm too trusting.
I just find it very funny that his entire business venture, was selling illegal drugs at festivals. That was the only plan. That was the whole venture. There was no...
That's really what he said.
Whether it was Scott, whether it was John, whether it was
But that
Joe.
was the business plan. That's Happy Pills. Thank you, by the way, for explaining what that was to me.
I didn't understand at first either, but when he said Molly at festivals, it's like, I'm pretty sure that's illegal. I'm pretty sure that's not a business.
Right.
So I'm glad she got her money back.
Me too. Me too. It was a ridiculous.
There was a couple dopes getting duped in that situation.
You're absolutely right.
Case 2107, Breland versus Chenal. All parties, please step forward.
Kashana and Michael Breland are suing Kashana's stepdad, Harry Schnall, for car repairs and damage credit.
Miss Breland, this is your stepfather.
Yes.
That's your dad.
Yes.
This is your claim. He needed a car because his car, which was an old Cadillac, was going in for repair. Your dad had bought you a car in 2018.
Yes.
And when he bought you this car in 2018, it was a 2013 car that you kept 18, 19, and 20?
The vehicle? No, I had the vehicle from 2018 to July 2019.
So just for 1 year?
Yep, July in 2019 was when I made the agreement to give the vehicle to...
Okay. You made the agreement to give it to your stepfather with the proviso, because you were buying a new car, another car.
Yes.
According to you, that he would take over the payments on the car because there was a loan on the car that you were paying off and that your father was a signatory on.
Yes.
And you have children, and I don't know why this car was no good for you anymore, but you said you got another car because of your children.
Yes, I got another vehicle because I had an additional son, and it just wasn't enough room for 3 kids.
What kind of car is it?
It was a GMC Terrain. It's an SUV 5-passenger, but I felt like I needed a little bit more room, so I ended up getting a 7-passenger. That way I could have the 3rd row.
Okay. So according to you, the arrangement was he would take over the payments on the car, and the car would be turned over to him as soon as he finished making the payments on the car.
Yes.
Was that your agreement with him?
Yes, that was our agreement.
And he did make payments on the car in 2019, 2020, 2021, and according to you, he stopped making payments in 2022. What month in 2022?
January 2022 was the last payment I received.
As a result of which, both of your credits were at risk. He dropped the car off at some relative's house because the engine was blown. He had it towed to some relative's house and stopped making the payments.
Yes, that is correct.
Your stepfather says, well, that really wasn't the agreement. My Cadillac wasn't working. It was in the shop in 2019. And the agreement was, while the car was in the shop, I would use your car and pay you $225 a month for it. But as soon as my car was out of the shop, you would take the car back. That's what you say, sir.
Yes. Yeah, I would take it back until my car got fixed. And the only reason it took so long to get fixed because of the pandemic, you know. And
why? People couldn't go into their garage to fix a car?
Yes, they probably could, but at that time, I really didn't have the money to go and pay for it, so I just...
Well, that's your problem.
I understand that.
Well, that's your problem. So the car was fixed, but you didn't have the money to go and pick up the car.
No, it wasn't fixed.
Oh.
So I didn't have them fixed until I'd be able to get the money to go have it fixed.
Did you explain that to her, sir, when she gave you the car?
No. See, my agreement thought I was going to keep the car until my car gets fixed and I would make the monthly payment. That's what I had.
I understand that, but what... Yeah. I understand that.
Okay.
Mr. Chenal.
Yes.
But taking your story, if my stepfather said to me, listen, I'll take your car, I have a car that's in the shop, I'll use it and pay for it while the car's being fixed.
Not what?
In my view, that would be, well, maybe it would take you 2 weeks. Maybe it would take you a month. Maybe it would take you 2 months, but it wouldn't take you 3 years.
Your Honor, what I'm saying, My car wasn't in the shop. My car was broke down. And I told her, I thought we had agreement to me make the payment on that car till I get ready to get
You told me that already.
Car fixed, but I didn't put it in the shop till I was able to put it in the shop to get fixed.
You devalued her car while you had it.
Yeah, okay.
You devalued the car. You got a car that was running. You used the car for 2.5 years that was running. It stopped running because the engine was blown.
Yes.
So it was dead stop. You had to have it towed to somebody's house.
Yes.
And then you stopped making the payments on it.
Yes.
Yeah.
Yeah. I hear what you're saying.
Right.
I think she had a lemon because...
She didn't have a lemon. You drove it for 2 years.
Yes, but I just had got the oil changed in that car a month before the engine blew.
And you drove it for 2 years.
Yes.
Well, then it wasn't a lemon.
Kashana and Michael Breland claim Kashana's stepdad, Harry Schnall, owes for car repairs and damage credits.
Now, you know, you have to act not only responsibly, but it would seem to me morally. This is your stepdaughter. You've known her for a long time.
Yes.
She went out, based upon her agreement with you, she went out and bought another car.
Yes.
Does the other car have a loan?
Yes.
Well, now she's stuck with 2 loans, and one of them has a car that you blew the engine on.
I made sure the main was up on that car. I think she had a lemon because...
She didn't have a lemon. You drove it for 2 years.
Yes, but I kept... Well, I just had got the oil changed in that car a month before the engine blew. I don't know why the engine blew.
How many years did you have the car?
2 years.
And you drove it for 2 years.
Yes.
Well, then it wasn't a lemon.
Okay.
How much was left on the loan of the car?
There is still $3,752.63 owed left on the vehicle.
Okay, and where is the car now?
It is parked at a relative's house.
Your problem is the car is in your name. So you have to sell the car, subject to this lien. You have to be able to get something for the car. Do you understand?
Yes.
What's the value of that car?
Based on 80,000 miles, it didn't say in the papers, but around 7,000 to 9,000.
And what if it's in very poor condition?
I have to look into it.
Take a look and see, because this car so far is not running.
Yeah.
And it hasn't been running for almost now a year.
Yes, that's correct.
So at best you could sell it for scrap. So you have to get the car and you can scrap it because nobody's going to buy it when they can't drive it.
So Kelley Blue Book will not provide an estimate for poor conditions, vehicles that are not running or in poor condition. But for a fair condition, they say between 5,000 and 6,000.
Well, this is non-running.
I know.
It's been
So
not running for a year.
I can't get an estimate for a non-running vehicle from Kelley Blue Book.
So now I know what the parameters are. You want to tell me about where this agreement took place with your stepfather?
The agreement took place at the car lots, because I was in the middle of getting a new vehicle, so we were at the car lot.
So that was in 2019?
July 3rd, 2019.
So you went with him to get the new car?
Yes.
Oh, good. So tell me about the conversation.
So I asked him, I was like, hey, do you think that, because in order for me to get this new vehicle, they said that I had a debt to income ratio thing because I couldn't get a new vehicle with owing money on the other vehicle. So I said, hey, how does this sound? You're down a vehicle because the engine blew on your prior vehicle. How about I give you this car, you finish making the payments on it, and then I get my new vehicle. But in order for me to get my new vehicle, I needed a co-signer. So I said, how about this? How about you co-sign on this new vehicle for me? Yes, my stepfather. You co-sign on this new vehicle for me. I'll make the payments like I always do. And you just take over the payments on my GMC Terrain. He said, okay, yep, we can do that because I need another vehicle.
So he is the co-signatory on your new car?
That at the time, that was the vehicle that I had. I now have a different vehicle.
You mean in 2019 you had yet another car?
Yes. But I made sure that I paid it off and there was no effect to him by any means. Okay. Because I knew that, it wasn't just in my name, it was in his name also. So I didn't want to do that to him. So I made sure that not only did I pay the vehicle off, but I got the transmission repaired and then I sold it.
So what does your father have to do with this case?
So my father was affected because with the payments being late.
The car was in my name also.
Oh, so it was in joint names, you and your daughter.
Well, they were supposed to put it as me, the co-signer, but they put me as
The primary.
Exactly.
Yes.
Okay, all right. Have you been making the payments since January?
I was making payments on it from February to September.
And then what happened?
I couldn't afford to make the payments anymore. I'm a single mom of four kids.
So what happened?
So it's behind now.
Since September?
Yep, it's behind since.
September, October, November. So it's
Yep.
behind 3 months.
Yes.
Had they notified you that they want to repossess it?
No,
they haven't
not
noticed.
repo. They've given us options to try to save our credit after
Okay, I'd like to see what those options are. Did they send it
What?
to you in writing?
No,
Did they send
No,
you
it
a
was
letter?
verbal on the phone when they called, and we were discussing other options that they may offer to
Okay, so
make
what was the
this so
best
it's not
option
worse.
that they offered you?
The best option that they offered was basically to come up with about $396 to pay to get the car note caught up because it was 4 months behind. The car note's $225 each month. So it wouldn't have got...
No. So they didn't offer you a whole payout. They just offered you
to catch up.
to catch up.
Yes.
Right.
Okay. But still, what's due and owing on the car is $3,752.
Yes.
Okay. And when your stepfather agreed to that, did he say anything to you with regard to his Cadillac going in for service and he was going to just use it until his Cadillac got...
No, Your Honor, that is incorrect.
Okay. You remember going with your stepdaughter when she was purchasing a new car in 2019?
Yes, I do.
Did you co-sign that car for her?
Yes.
So far what she says is accurate.
Yes.
And at that time, did you take her old car?
Yes.
I have no idea what you can get for this car. And you know how you relied on him to be a good guy and to do what he was supposed to do?
Yes.
I'm awarding you $3,752. That's for you to pay off the bank. Then I don't think you can find a buyer for this car. You may have to scrap it, right?
Yes.
It's possible that there's no point in fixing it. You're not going to invest thousands of dollars in fixing it when it probably is at best worth $5,000. And if it's going to cost you $3,000 to try to get it up and running, it doesn't pay.
11,000.
It doesn't pay. So I'm going to rely on you to do the right thing. It sounds as if you do that while I'm awarding you $3,752, whatever money you get for the car goes to him. Do you understand? If you scrap it for $70, he gets it. I don't see that it's worth much more. I certainly wouldn't invest in a car that's been sitting dead for a year with a blown engine. Judgment for the plaintiff in the amount of $3,752. We're finished.
This court is adjourned.
I think it was pretty fair.
I think it was very fair.
My agreement, though, I pay for the car until I get my car fixed.
I've tried multiple times to reach out to him, and I couldn't get a hold of him, so it's really sad that it had to come to this.
She had to do what she had to do. That's all I can say.
I've learned that you can't help anyone, not even family.
Time to move on. Go on about my business, yes.
I'm a nice person, so I guess you just sometimes can't be nice to everyone.
You know what's so disappointing? She seems like a very lovely young lady. Her father seems like a nice man. He had actually helped to purchase the first car, and I think co-signed a loan for her or bought her the car in 2018 that she then turned over to him. But he's been her stepfather for a long time. How could you be so irresponsible?
And you know she's a single parent of 4 children who relies a lot on her credit.
And her credit on her car.
And
she's maintained her credit.
Yes, except for the fact that her stepfather sort of ruined it for her a little.
He really didn't have a defense.
No.
I don't think he had a defense. I don't think that you borrow somebody's car until your car is fixed 3 years later. I don't think that's...
Terry Smith is suing her ex-husband, Tony Smith, for 3 ATVs and a lawnmower.
Court cut in order. All rise.
Have a seat, please.
Hello, Judge. Case number 2148, Smith versus Smith.
Thank you. Miss Smith, this used to be your husband. You haven't been married in a long time, but after your divorce, you sort of remained friendly and you had some business transactions together. What kind of business?
I would refer real estate business to him and refer flipping homes and the construction work.
Did you take part in that as well?
I did.
In what year were you divorced?
2015.
So this briefly is what I gather from the complaint and the answer and the counterclaim. At some point, according to you, you purchased 3 ATVs. Those 3 ATVs were originally supposed to be used in business.
We purchased more than 3.
How many did you
Those were
purchase?
the 3 that were left. It was 14 of them that we had.
And when you purchased those together as part of a business?
No, those were mine. I purchased it. The business.
14.
Business was mine. Yes.
14?
Yes.
You purchased them, you paid for them?
Yes, I did.
Okay, and you can prove that to me?
I can.
Okay. Do you agree with the fact your former wife purchased the 14 ATVs?
Yes, I agree, but it was underneath an LLC that was formed.
I don't care whether it was under an LLC or a little umbrella or a big shoe. She bought the ATVs.
Yes.
So one of the things that's in question is the ATVs now are in your custody?
The remaining ones are in my home, yes.
3.
Yes, ma'am.
And you want them back?
I do.
She bought them. Why doesn't she get them back?
Because, Your Honor, there is an outstanding invoice for work that I have done for her.
What?
It's construction work and other odds and ends that was helping her.
That's not part of your counterclaim as a set-off, sir. That's not what you say at all.
Okay, and also there is a counterclaim.
You have a counterclaim. That has to do with your truck. So there really is no reason that you are holding those ATVs. Are they new?
No, they were demonstrator models. There's 1 new one and 2 demonstrators.
Okay. So within 5 days, you make arrangements to get those. Okay? I assume that you have children together?
No.
So I assume that you are 2 civilized people. I don't know whether you need a police officer to accompany you to get those, but within 5 days, make arrangements to pick them up from his house. They're yours.
I will. Thank you.
Are we then finished with your claim?
Now, there's a lawnmower, an electric zero-turn lawnmower.
Okay.
It's also part of that claim.
Okay. I sort of remember that. Is that an old lawnmower?
No, it was purchased in May of 2021.
And who was it purchased for?
He asked me, since he could not get it on credit, if I would buy it for him, and the next real estate transaction that I referred him, he said when he got paid, he would pay me the $4,800 back.
Okay.
And so when I asked for it, he said he had put it in a separate savings account to save it for me. And I said, well, I don't need you to save me my money.
Got it. So you have the lawnmower?
Yes, ma'am.
You picked that up with the ATVs.
Thank you.
Got it?
Thank you.
Perfect. Now we have to come to your counterclaim. Your counterclaim is sort of interesting and can be, I think, probably equally swiftly disposed of. After your divorce, you needed a truck. You didn't have any money or credit, according to what I've read, and you purchased a truck in your name for him. And the agreement was that you would make the payments on the truck because you couldn't get credit. Is that right?
Yes, ma'am.
The truck was purchased in what month and year?
August of 2020.
How much did the truck cost?
$58,000, somewhere in there.
And how much of a down payment did you put down?
$500.
Is that right?
Yes,
That's good. You must have had good credit.
I do.
Good. And what were the monthly payments, sir?
900 and I can't remember exactly. It was under 1,000. It was 940 something dollars, I think.
And you paid for the truck the month of August of 2020 and all through 2021. Until when? When was your last payment on the truck that you made, that you can prove to me that you made?
I have all the payments.
Just tell me, when was the last payment you made on the truck?
It was August of this year.
August of 2022.
Yes, ma'am.
And that's what your bank records will indicate, that you made a payment of $900 and some odd, August of 2022. And in what month did your former wife repossess the truck, which was in her name?
It was September 20th.
Now you're going to tell me why you repossessed the truck. Let's talk about the violations. Driving without tags, only 2 months. When we forget or we're traveling and we don't get registrations for our cars, we don't drive those cars. Because if you're driving with expired tags, that's against the law.
Terry Smith claims her ex-husband, Tony Smith, owes for 3 ATVs and a lawnmower. Tony is countersuing for the value of a truck.
Okay, you made a payment of $900 and some odd dollars.
Yes, ma'am.
August of 2022. And in what month did your former wife repossess the truck, which was in her name?
It was September 20th.
Okay, now you're going to tell me why you repossessed the truck.
Yes, that truck's first payment was due on October 30th of 2020. I made the payment on November 28th.
No, I'm not interested in history.
Okay.
I'm interested in, he says that he was making payments on the truck. You say he stopped making payments on the truck, which is why you repossessed it. You didn't want your credit to be at risk.
It was two of the first payments that I made, and I said, I'm not doing this again like I did on the last truck where I make every payment. But the insurance, I asked for the insurance to be paid since April of 2020, and I requested this on June the 28th of 2022, and I said, here's the insurance premiums I've paid on the GMC truck since we've had it, and it was $1,596. His reply was, I'm happy to pay the insurance on my truck, but don't just dump 2.5 years on me at a time. I will need to break this up into 3 increments. This was June. I don't have any money. The insurance and taxes, the taxes this year is the first time he's ever paid taxes on the vehicle, and it was 1 year late. He drove on an expired tag for a total year. The reason
Is that just a second, is that correct?
I'm sorry?
Did you drive on an expired tag
No,
for a
ma'am,
year?
it was only a few months late.
So you drove
It wasn't an entire year.
How many months?
2 months.
Oh, that's too long.
I agree.
And was your agreement that you would maintain the insurance for the truck as well?
That was something that we discussed, and because of the real reason she actually agreed to purchase the truck, we had a previous truck that was also I was driving, and because of the LLC that the truck was under, it was a very high commercial insurance rate. So she felt that it would benefit her to get another truck and come out from under the commercial rate that she was paying for insurance, and she was going to put it in a group insurance policy.
Where is the truck? Where is the truck? You've had possession of the truck.
That's correct.
So you get all the benefit of the truck, and she gets all the detriment.
I'm just referring to what we
I'm
discussed.
just what I'm not getting from you, sir, is any sense of the whole idea was this is going to be my truck. As soon as I finish making all the payments on the truck is going to be mine, right?
That's correct.
And if you didn't make payments on the truck, absolutely, she has a right to repossess it if that was your agreement. And you acknowledge that that's your agreement, right?
That is the agreement, but I have made every payment, and I have paid all the taxes.
Well, the word paid all the taxes eventually. Didn't pay them when due.
That happened once.
Didn't pay them when due, pay them eventually. What about the insurance?
The insurance, I agreed to catch up and pay her back for once she told me what it was.
Okay.
I never received any information about the insurance amount until she sent it all in one.
Okay, she sent it to you in one email. That was in June, and you said I couldn't pay it, and she repossessed the car in September. Between June and September, did you make any insurance payment?
No, I did not.
Why?
It was a lot of things going on at that time that there was money owed to me as well from her. So it was a lot of discussion going back and forth about that.
Well, but one thing is clean. You know about the insurance, and if there's money that she owes you from construction or real estate or whatever it is, you have to put that in compartments. Where is the truck now?
I took the truck back and it is sold.
Did you ever tell him?
He wouldn't talk to me. He hasn't talked to me since May.
So you had the truck for approximately 2 years?
Yes, ma'am.
And how much in total did you pay for the truck?
The exact amount added up was $18,736.
So you paid approximately $9,000 a year, right?
Correct.
Your Honor, we had an agreement of $1,200 a month on the truck to cover the insurance and taxes up front before it was purchased.
That's not true.
Well, if you paid approximately $9,000, Mr. Smith, and you used it for business, correct? That's what you used the truck for. So you paid approximately $750 a month if you paid $9,000 each year for the 2 years, $1,870. You say the payments were $900 a month. That means that there was a shortfall.
Can I bring us? It was more than 2 years. It was August of 2020 until
September.
August of this year.
Well, that's 2 years.
There's also a down payment
Of $500. I'm not.
Okay.
So that's $750, sir. I always have a problem with people who are no longer married and no longer happy with each other, where one party has the obligation and has all the liability on a vehicle, including their credit and their insurance, when the other person is being either irresponsible or blinking at certain violations. Let's talk about the violations. Driving without tags, only 2 months. When we forget or we're traveling and we don't get registrations for our cars, we don't drive those cars. Because if you're driving with expired tags, that's against the law.
I would like to point out, if I may, that the bill for that obviously went to her address. It was not given to me. Now, that's not my. I understand that I need to be aware of it, but I never received that bill.
I gave it to him the very month it came in.
Just a second.
That's not true.
Just a second. You're a big boy. You know when your car has to be registered, you have a little yellow tag on the back like everybody else. And insurance, you know, you're supposed to pay insurance. That was your agreement. You were supposed to pay insurance. And you didn't pay insurance. She's going to show me how much was left on the loan and how much she sold the truck for. If she sold the truck for more than was left on the loan, the difference between, you're looking at me, the difference between that belongs to you.
Terry Smith is accusing ex-husband Tony Smith of wrongfully keeping 3 ATVs and a lawnmower. Tony claims Terry owes him for the cost of a truck.
Okay, well, are you working now, sir?
Yes, ma'am.
Great. She sold the truck. How much did you sell it for?
$48,000.
And how much was left on the loan?
48. It was even.
Well, show me.
It was even. Oh.
I'd like to see that.
Ooh.
So $48,000 was, he paid $18,000.
Hang on 1 second, I got it.
Can I submit this to you?
What is that?
Or this, my bank statement showing the payment?
No, you told me. I accepted it.
Okay.
She doesn't dispute it, and I accept it.
I do have a copy of the title here somewhere.
What I'm looking for, Mr. Smith, just so that you know, what I'm having her look for me, she's going to show me how much was left on the loan and how much she sold the truck for. If she sold the truck for more than was left on the loan, the difference between, you're looking at me, the difference between that belongs to you.
Oh, I see.
Because you paid it, right?
I see. Yes, ma'am.
Got it? That fair? Did she tell you that she sold the truck?
No, ma'am.
He went and bought a truck 2 days later, so he was able to buy a truck.
Okay.
I mean,
would you find those papers for me while you're looking for those papers for me? Mr. Smith, did you buy another truck?
Yes, ma'am.
Good. Did you put a down payment on it?
Yes, ma'am.
And you own it now?
Yes, ma'am.
And you're driving it now?
That's correct.
What would you do with a second truck?
Well, I was forced to buy one because I
understand you were. I understand you were forced to buy one, sir. But if you had the truck and you weren't going to use 2 trucks, you would sell this truck for whatever amount you sold it for, and if there was any overage, you'd get to.
I offered to purchase the truck from her. In fact, she understood that I was planning to purchase the truck from her.
Don't tell me what she understood. Right now, you don't need a truck, and I'm going to find out whether or not she has to give you any money as a result of what she sold the truck for.
This bill of sale does not have the amount on it. I didn't realize that. I'll have to get that from.
Well, this is the time to get it.
I'm sorry, I did not realize it didn't have it on there.
Okay. Oh, you sold it to a company?
I did.
Oh, okay. Not to a private party?
No.
Is that the same company that you purchased it from?
No, I purchased it from a different dealership.
Okay. Do you have the exact amount that the loan, the extant loan was?
The original loan was $60,000.
No.
I'm sorry. The exit loan?
Yeah, the exit.
It was between $48,000 and $49,000, give or take. Hang on.
And the truck was, and the truck.
I have it.
Was purchased for $56,000, so that amounts for his payments plus interest.
I have it. That's the difference of what they gave me. I originally put the down payment on that truck as well. He did not.
That doesn't matter.
Yeah, that was the difference they gave me in the sale.
Okay, so this is the difference.
Yes.
Between what was on the loan.
Exactly.
Between what was on the loan.
Exactly.
And this. Okay, so the excess, sir, was $2,225. She put in the deposit for the truck when it was originally purchased of $500?
She did not.
Yes.
Who did?
I did, and I have a copy. I have that in this record right here.
Show me.
We added tires. We added all kinds of extra stuff and everything to it. I paid for that.
I don't care. I don't care.
Yeah.
This is actually.
Just show me.
It's on my phone. Can I show it? Can I?
From 2020?
Yes, what had happened, the amount actually came off of this statement copy.
Let me see.
Can I submit this to you where I made the 2 payments on the truck? When he first started, I made the very second payment and the 4th payment on that truck because he wouldn't make it. I also notified him on June the 20th that he had 30 days to get the truck in his name, and I never heard anything.
You can't notify him within 30 days to get it in his name. That's not the agreement. Let me see.
Yeah. There's this.
Yellow.
Yep. Purchased authorized August 22nd, and this is 2020 for $500. Okay, so the difference of $500 that came out of your account brings the total excess that she received $1,725. She's coming to pick up her lawnmower within 5 days and her 3 ATVs. At the same time, she's going to give you $1,725, which is the difference between what was owed on the truck and the profit that was made that she didn't pay for. We're finished here. Thank you very much.
This court is adjourned.
I think it was fair.
Well, it was a little less than I thought I was going to get back from it, and there's a lot more to the story that obviously I couldn't get in.
Well, I mean, I had the truth, so.
She understands why that is because there's an outstanding invoice from me for work that I've done that she's refusing to pay for.
I have supported him since 2003.
Construction work, I did a lot of planning and helping her with her current home that she's living in.
It is just one thing after another, and I could never owe him one dime.
I mean, everything was fine between us.
Has trauma bonded me and manipulated me and gaslit me for all these years and kept me around just in case other relationships didn't work out.
Until she found out I was seeing someone else.
No. I had been asking for everything of mine that he kept and held hostage for a long time before that, but he's probably had many more before that. I just didn't know about them.
But I'm happy.
I was thinking he was making me think that we were reconciling while he was using me.
I don't see us talking anymore.
The bank is finally closed, and the bad bargain has just been a nightmare. It's been hundreds of bad bargains.
No more business ventures.
You see, it's always a mistake, unless you're married, to co-sign a loan for anybody, a boyfriend, a somebody.
An ex-husband.
Especially an ex-husband.
Yeah. Because I think what you said was true. There's always one person that gets no benefit and gets slighted and has their name on the line for their credit for future purchases that they want to make, and the guy who gets to drive the truck.
And the guy gets to drive the truck. Of course, he says that the reason she got all hot and bothered is because he has a girlfriend now. I would have felt a little more sympathy towards him had he not gone out 2 weeks later and bought a new truck.
Robin Slagle is suing her customer, Jack McCurcheon, for tuition and administrative fees.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2126, Slagle versus McCurcheon.
Thank you.
You're welcome.
You run a school.
Yes, ma'am. It's a program.
Is it a school or a program?
It's a program.
What's the difference?
The program is not a school where the children come every day. They come twice a week. Parents...
They come twice a week online?
No, we are
in person.
In person, yes.
Okay, so twice a week they are there at a brick and mortar place?
Yes.
And how long have you had this program?
We actually started this program during the lockdown in 2020 spring. So this is at the end of our first semester of our 3rd year.
Okay. And tell me, who runs the program?
I do.
You have an educational background?
I do. I have a master's in education.
Does anybody run the program with you?
I have a staff, but I'm the sole director.
Is this an annual program?
We do operate on a semesterly basis as far as payments, but the classes just roll over from first semester to second semester.
And is there a contract?
Yes.
Okay, and you're going to show me the contract that the defendant signed on behalf of his son?
Yes.
Because that's what this case is about.
Yes.
The only interesting part of the case is your son was enrolled in the program. He was terminated from the program for, let's say, misconduct.
That's true.
And it was misconduct that was replicated in violation of the rules at least 3 times.
Kind of.
Not kind of, at least 3 times that you acknowledge.
Okay.
That's not an okay. That's not an okay. That's either a yes or a no. I mean, I read about 3 instances of cheating. You acknowledge that in your answer.
Well, it's different. It's different.
You mean he cheated differently?
No, he didn't cheat
Yes, well,
differently.
that's what...
I mean, I can explain.
It was explained in the papers.
Okay.
And you weren't there, so you can't explain. But you acknowledge the fact that he cheated. He was given a warning. You were advised. He cheated again. You were given a warning, and he was allowed to continue. On the 3rd such event, the school terminated him. Is that what I read?
Yes, ma'am.
And that's what you acknowledge in your papers?
Yes, yes.
Okay, well, that's a yes. And he was within a semester. You had paid the tuition and then tried to reverse the payment because you paid on a credit card.
Yes, I paid with credit card, yes.
Okay, and then when you got the bill, you challenged that payment, which you had in fact received, and whatever you told the credit card company as a result of what you told them, the payment was reversed and taken off your credit card.
That is correct.
Right. And so they are here now seeking that tuition payment from a court. That's why we're here, to see whether contractually, because this is a breach of contract action, you were obligated to pay the tuition even though your son was not in the program because he was dismissed for cause, which you acknowledge. Are we clear on where we are?
Yes, ma'am.
Yes, ma'am.
Good. So now I'm going to look at the contract.
I'd like to add that...
Just let me look at the contract first.
Well, if you see contract, they're signed by my party. I want to see it too, because I don't see my name. I sign a contract. That's a statement, probably, or it's a...
It's a payment agreement.
Yeah, yes. That's not a contract.
Yeah, payment agreement is a contract, sir.
But signed by me?
Well, it says signed, Arena and Jack. Okay. Is Arena your wife?
That's correct, yeah.
Okay. So this says, I understand that payments are due even if classes or memberships are dropped, subject to the refund policy. Well, what's the refund policy, and where is that in writing?
It is on our website, and they've signed it. It was a form that they had to sign.
Well, I'd like to see the form that they signed, because I have to see what the terms are of that.
These are the terms of the refund.
Thank you.
That's a screenshot of our website.
No, the website is unimportant to me. You say you have an agreement signed by them. I'd like to see it.
Well, the agreement that we have signed was the installment agreement, so I'm sorry.
Well, I only have one payment agreement. What I said I want to see is a refund policy. You said you have that they signed. I don't see
They don't sign the policy. They sign the agreement. The policy is a written policy.
Well, I would like to see the written policy.
That's what we have on our website, and it's clearly...
No.
No? Okay.
No, what you have to do is you have to incorporate something by agreement in this contract. If you say the refund policy as outlined in the website, because other than that, it's meaningless.
Okay.
You know, you're saying we have a refund policy, and we assume that you looked on the website to see what the policy is.
We also do go over it in parent meetings with the parents.
That you can't do because you have a written agreement.
Right.
And anything that's outside of that agreement, unless it's referenced in the agreement, is inadmissible because the intention of it is to somehow change or modify the terms of your written contract. Okay, so in what month did the defendant's son start the program?
In August of 2021.
And it runs in 2 semesters. And when was he terminated?
He was terminated in February of 2022.
You're in a semester program.
Yes.
So am I correct that the first 2 episodes of cheating were in the first semester?
Yes.
When?
The first one was early in November. It happened to be the 3rd week of our 2nd semester. The next one was a couple of weeks later in the same month of November.
Okay, so the semester had started.
Mm-hmm.
Uh-huh.
Semester.
Yes. Mm-hmm. And on what day in February was he terminated?
He was terminated on February 24th, I believe. Yes.
And when you terminated, the defendant, I assume, paid the entire semester's tuition for the 2nd semester.
The 2nd semester, he signed the installment agreement, which is what you have there.
This is a payment agreement.
Right. That's it. He agreed to pay in installments.
No, it says I agree to pay all charges by due dates according to the payment plan. I don't have a signed payment plan from anybody. Do you have one?
I'm sorry, that's what we use for our signed payment plan.
Well, you should use something different. This is not a payment plan. This says he will pay according to a payment plan. Mm-hmm. I'm looking for the payment plan. You pay by the month, you pay by the semester. How do you pay?
It's a semesterly fee that's broken into 4 payments, so they don't have to pay it all up front.
Okay.
They can choose to. But
and so when was the defendant's last payment?
They paid through the semester.
Through what semester?
2nd semester.
Okay, so they paid in full.
Through the installment. So what happens is they agree to be automatically billed. And so every month, a certain amount comes out.
Just a second.
Mm-hmm.
So what you're saying is when they sign up, they give you authority to pull out from their bank.
Yes.
Whatever the tuition is for that month.
Right.
Okay. And according to your records, when was the last payment that you received for the defendant's son prior to terminating him?
Prior to terminating him, we received a payment in February.
And you terminated him on February 24th?
Yes.
How much was that payment?
It was, have it right here. You know what? I don't know.
$350 every
It's
month.
$300, that's right. $350.
I know, I got charged the extra month, so I know the number.
Okay, so it was $350 that you paid the beginning of February, and he was there in February.
That is correct.
Okay. In what month did you dispute the charge?
Well,
No, not well. I said, in what month?
May. I only realized in May she's been charging.
Just a second.
He was plagiarized by teachers.
It was plagiarized by teachers.
He was given notice because he lied on a test by teacher, yeah? But it's not exactly what happened.
They're not in the business of expelling children. They're in the business of keeping children in school.
But
you really have to get this through your head.
Robin Slagle claims her customer, Jack McCurcheon, owes for tuition and administrative fees.
So you paid in February, and your son was there in February.
That is correct.
Did you pay in March?
It was taken out of my account without me knowing, but yes.
Is that $350?
That is correct.
And did you pay in April?
I did pay in April.
Okay. Now, the May payment, is the May payment the payment that you canceled?
No, on the May, I also paid for a May payment. Looking at my statements, I said, why are we paying for the child? He doesn't go to school anymore. And that's when I called them. And then I called my credit card company, explained to what happened. They said, we are going to charge the money back to your account. And that's when I kind of looked through paperwork. And I'm an immigrant in this country. I don't read really well. I can speak. And my son, he's a young guy, and he knows exactly what it is, and that's what I brought him. I said, can you see, do we owe these people money? And if you guys allow it, I can have Alex to explain what here shows.
Just see it. He doesn't have to explain anything to me.
Okay.
I'm not new to the country, and I was legally trained, so I don't need your son. I assume you're not legally trained?
I am not.
To interpret something, a piece of paper. So now I will look at the piece of paper that you're relying on, but I want to tell you this, sir. I pay the tuition for a lot of people, a lot, because I have 13 grandchildren in school.
Okay.
I'll take that, Kevin. Thank you, I'm sorry. I know that if one of my kids or grandkids goes to school and gets expelled, and I pay the tuition, because I'm not on a payment plan, parents send the bill directly. and so I pay the tuition, but I know if one of the kids in November, once I pay the tuition, gets caught cheating on a test or plagiarizing a paper, and he or she is dismissed from the school, they're not going to give me my tuition back, even though he's not in school. I'm not going to get the tuition back for that semester.
That's true.
That's what I'm telling you. I know that. So now I'm going to see what you want me to read that suggests that in this case, even though your son was terminated for cause from the school for cheating.
Dismissal versus termination is different.
No, it's not different at all. It's this exact same thing. Dismissed, terminated, expelled, all the same thing. If you look them up under synonyms for each other in the dictionary, you will find they're all the same. He was excised from the school because he cheated despite multiple warnings. So he was expelled from cause. I just want you to understand that. Did you go to college?
Currently enrolled.
Currently. Stand up. You look like a nice young man. Where do you go to school?
Cal Poly Pomona.
And who pays the tuition?
I do.
Now, what's your first name?
Alex.
Now, Alex, you do know that if you got expelled from college for cheating in the middle of a semester, you wouldn't get your tuition back for that semester. You do know that?
Correct.
Okay, that's all I want to know. Well, that's what we're dealing with
here. Could I add something?
Sure.
Well, according to their honesty policy, they made a clear difference between dismissal and expulsion.
I'm going to look at it. Okay?
Okay.
Okay, so what you gave me now acknowledges that you received the refund policy. Thank you very much, because she wasn't able to prove that she gave it to you, but now you gave it to me, so I know you were given the refund policy when you enrolled your son in school.
So we weren't given, but it's something they have it on their website for you to...
Just a second. Well, then you look. You don't have to sign. Then you looked at the website. You gave me this. Do you understand?
After
That's what I
this
mean,
happened,
legal.
I went and tried to understand.
Well,
what
you should have
happened.
done it before.
Well,
you were
I own a
perfectly
construction
capable of
company.
doing it
when
before.
I sign a contract, I sign and I explain everything.
You
and
just
people
told
get
me
copies.
5 minutes ago that you didn't sign any contract. Well, now you acknowledge that you signed the contract. I'm just reading this that you gave me.
A contract has to be a complete contract. If there is something...
For somebody who's, not here, not from this country, and doesn't understand things, you seem to understand things very well.
I know the contract has to be completed.
Well, that's very good. A lot of people don't know that.
So if I give a contract for a statement, then I say, go in my website to read about our refund policy. That's not part of the contract. That's their rules, no? I didn't sign refund policy.
You don't have to sign a refund policy. You just have to be aware of it.
If I don't know how to get into website or don't...
You gave me the evidence,
But this was done after everything done. I
I'm
looked
not sure.
into it. Okay?
You were certainly aware of how to do it, either before or after.
When I sign contract with someone, I disclose everything, and they initial, and they get copies. I get copies, and that's a legal bonding contract.
Good. What law school did you go to?
None.
Well, there are two things here, but the final piece here says the consequence for academic dishonesty or plagiarism is a score of 0 on the assignment and possibly dismissal from the class.
Okay.
So your son did that in the first semester at least twice. Repeated dishonesty can result in suspension or expulsion. Now you can stand up because your father says he doesn't understand everything. I think he understands everything just fine. But in case he wants to have you there. Now, when you were discussing this with your father, did you have any conversation with him that suggested to him that, if I went to college and I cheated 3 times or 4 times and plagiarized a paper and I was kicked out of school, I wouldn't get my tuition back? Did you tell him that?
No, we had similar talks, but no, nothing on the school. We talked about, for instance, the signing contract for, let's say, a 1-year lease agreement to live somewhere, but if you breach the contract and they decide to kick you out, it's the same thing as expulsion. You're not required to finish the 1-year contract with them. You don't have to continue paying.
If they decide.
What are you kidding?
I am not. If you get evicted from a property, do you have to continue paying the entire year's lease?
Yeah. If you breach a lease, he or she can evict you. And yes, you will be responsible for the remainder of the lease.
Oh, I was unaware of that.
Yes, you will be responsible for the remainder of the lease. You have to understand, and your father has to understand, the reason that he was expelled is his fault. And the reason he was expelled had nothing to do with them. It had to do with your father, because you were put on notice that he was plagiarizing and cheating on tests. If what you're suggesting is the 3 times that your son was caught cheating were the only times he cheated, you're deluding yourself. He got caught 3 times. Because if these were the only 3 times that he cheated, he is the unluckiest person on the planet.
Robin Slagle has accused her customer, Jack McCurshian, of refusing to pay tuition. Jack claims he is not required to pay because his son was dismissed from her school.
You were put on notice, and instead of being more vigilant, the conduct continued. He lives in your house. How old is he?
14.
14. Well,
I want to ask about this plagiarizing thing, which it is, because remember, beginning you asked me that he was plagiarized by teachers, which I was not.
He was plagiarized by teachers.
Like he was given notice because he lied on a test by teacher, yeah? But it's not exactly what happened.
Well, then you should have, just a second, then you should have contested it, sir.
Well,
you should have contested it. Did you say?
If they don't want him to be out of the school, they don't want him to be there.
No.
What do you do? I mean, you go fight with them?
What do you do? You pay the tuition for that semester because that's your contractual obligation, and you tell your son, you better straighten up, and if I have to take you to a psychiatrist, if I have to take you to a therapist, if I have to find a more rigid school environment, I'm going to do that.
Well, he really didn't cheat.
You really have to get this through your head.
When he says cheating, last time he was expelled from the school. Do we have a...
No, don't look at her.
That day he had an excellent score on his math, and his last test was his history, and he forgot to learn the history, and he did have a paper with him, but he did not cheat it. Actually, there is no proof he cheated that day.
All right. They're not in the business of expelling children. They're in the business of keeping children in school. How many other students were expelled from the school the semester that this defendant's son was expelled?
0.
Yeah.
Wow.
They're in business of keeping children in school.
I guess my son was that bad for her to expel her.
She said they didn't expel any other children. I'm going to ask her, how many children were enrolled in the program at the same time the defendant's son was enrolled in the program?
Approximately 70, 75.
Okay, and of the 70 to 75 students, the only student expelled was the defendant's son.
Yes, ma'am.
That should tell you something, sir. Stop making excuses. Okay. I didn't tell you, he didn't look at the paper, he had it underneath him, but he didn't look at it. Well, plagiarizing, so he copied from somebody on a paper that was supposed to be original work, did it once, he did it twice. Do you understand your son has a problem?
Well, we all have problems.
No, I never had a problem being expelled from school, sir, for cheating. I never had a problem being expelled from school for cheating.
I have lied.
I have 5 children and 13 grandchildren. All have completed college, some professional school. None of them have ever been expelled for cheating. That's a lot of people.
Do you feel it's fair to expel a child from a school because of
cheating?
Cheating?
Absolutely. Not that I usually let people ask me questions, but the answer is absolutely. Because if 70 children are working hard to get good grades and studying and creating original works when they're supposed to create original works, and your son who's getting a 99 on a math test when he's been getting low scores on tests all of a sudden becomes a shining star one day, and it's a pattern, and then they find another cheat sheet under his bottom. That's something that suggests to the other 70 students that are trying to do the right thing, that it's okay to cheat. And so if you want to cheat on this test to get a 99, it's okay. You can't run a school where you permit kids to mingle with kids who are trying with kids who are cheating. So do I think it's fair? Absolutely. Okay, how much money was reversed by this bank?
$1,050 plus $45, a $15 fee per transaction.
$1,095. Okay, judgment for the plaintiff in the amount of $1,095. Sir, your problem is not with the plaintiff. Your problem's with your son.
He's like all of us. He made a mistake, and
No, he didn't make one mistake. I'm going to tell you something. Honestly, I used to say when I was practicing in a different court that if criminals got caught the first time or every time that they committed a crime, they'd stop committing crimes. Problem is, they commit a crime and they don't get caught. And then they commit another crime and they don't get caught. Then they commit the third crime and they get caught and they're brought to court. And their lawyer argues this is their first arrest. Not their first crime, because they can't argue that, but it's a first arrest. So if what you're suggesting is the 3 times that your son was caught cheating were the only times he cheated, you're deluding yourself. He got caught 3 times. Because if these were the only 3 times that he cheated, he is the unluckiest person on the planet. Okay, we're done here. 1095, judgment for the plaintiff.
Thank you, Your Honor.
This court is adjourned.
I felt the difference was between different wording, what it means as far as being expelled versus being like sent home.
I'm extremely pleased. This was totally a matter of honesty and integrity. And obviously, it stems from the father down to the son.
But he explained that's the same word. And again, that's why you come to court, and she did what she had to do.
We have kids that try to cross the line, come close to that line. But as I mentioned, our instructors are pretty savvy and they're on it, and we can tell pretty much, so.
I am happy finally done. It's been a burden, it's been a stress, and hopefully it's done.
Cheaters never win.
So I think it's really important for the plaintiffs, as the runners of a homeschooling system or a schooling system, to have a better contract for the parents that are signing, especially with a payment plan option. There should be exhibits attached to the signature page, not just referencing, oh, we're agreeing that we read the policy from the website. It's just as easy for you to reprint it, attach it, and require a signature, an initial on the bottom, so that you don't have parents like these that say, I never went to the website, I never saw it.
I agree with you.
If you have problems like this, there's no denying the fact that you initialed each page and each policy.
I think that it's a learning experience because they just started the program in 2020. And this is probably the first experience that they've had because he's the first never expelled anybody else. But they'll clean up the contract.
Paul is suing his neighbor, Stacy Benedum, for breach of contract and attorney fees.
Court come to order. All rise.
Have a seat, please.
Case 2128, Hall versus Benedum.
Thank you.
You're welcome.
Mr. Hall, you and the defendant are neighbors.
Yes, ma'am.
And your houses are right next to each other.
Hers is on the corner, mine is
right next to her.
Yes.
Got it. What your complaint is that I see where those two, the truck and the vehicle behind it.
The trailer, yes, ma'am.
The trailer. The property to the left of that is your house.
Yes, ma'am.
And the property to the right of that is the defendant's house.
Yes, ma'am.
And it is your claim that the defendant, in writing, agreed to sell you that little piece of property that looks like it's been carved out of her property.
Yes, ma'am.
Because you had a narrow driveway, you wanted to park these two vehicles.
Yes, ma'am.
Based upon that agreement, you went ahead and did some work on that piece of property.
Yes, ma'am.
You put down gravel, you planted flowers, all to make it look as if that piece of property was part of your house.
Not so much to make it look like it's part of my house so I can get in it, because the agreement was that there was 3 pine trees there prior to her telling me that I could buy the property.
No. The 3 trees that are there had nothing to do with this except that they were taken down. And were they taken down and the removal of the trees was paid for by you or by her?
By both of us.
By both. Okay. So you asked to have the trees removed, and you both paid to have the trees removed.
Okay.
Not only did you cut the trees down, but you took that property and made it look like yours. You say that there was an agreement in writing for her to sell you that piece of property. So I'd like to see that agreement.
Yes, ma'am.
There's no agreement in writing.
Don't say anything.
The very top line.
Just a second. This is not a contract, sir, to sell land.
I have a lot more.
Shh. Not a contract to sell land. I see what she says to you. I am agreeing to sell you the property you are currently parked on for $1,000 plus costs. Let's get this in motion ASAP. And then she doesn't hear from you, and that's the 18th of May. And then she writes you again a little bit later, and she says her offer will expire at the end of today's business day, 5/19. And on 5/19, at 10 o'clock at night, you write to her, hey, Stacy, I've started working on things this morning. I have already been to the city of Akron, and once they are done and I get a surveyor and so on, I will keep you updated if that's okay. Last, everything is time sensitive, and I'm working as fast as I can to get the approvals. Just now seeing your texts.
Right.
Okay. So that's what you're relying on as a contract to purchase property.
Well, the fact that she said that she would sell it to me, and I started all the motion like she said to do. I started all the motions, got the survey done, got the deeds done, I got everything done.
All right. That was 5/19/2021. So show me what you did based on this and what you spent based on your belief that she had agreed to sell you the property and you had an agreement for sale, which is like a contract to sale of property. Most people know that when you sell a piece of property, you get a survey, you put it in the contract, you have a contract when the property is going to be transferred. That property would have to be surveyed because clearly you're carving a piece of property out of her property. I want to see what you did and what you spent, because if you spent money based on this, I may consider that as part of your lawsuit, because then it turned out she didn't want to sell you the property. By the way, I wouldn't sell him the property either. It makes your property look ridiculous.
It does. We never agreed to sell the property. Okay.
Did you write, I am agreeing to sell you the property you are currently parked on for $1,000 plus costs?
Yes, I never agreed to sell the property until I told him he was no longer allowed to park there. It was never discussed.
What is
Depending on the stipulation that my mortgage company requires, which is an appraisal, they had to approve the selling of the property.
All I'm interested in is this one line. The other ifs fall after that. It says, I'm agreeing to sell you the property you are currently parked on for $1,000 plus costs.
Yes.
Okay, so you did that.
Yes.
I want to see the things that you started to do right after May 19th. You said, I've already started working on things this morning. This is May 19th. I've already been to the city of Akron.
Yes. This is a receipt showing the $800 from the surveyor.
Okay, may I see that, please?
There's that one. This is a receipt from the attorney where I had the deed paperwork done.
I'm looking for a date on this, sir. I'm looking for dates on these things.
Look at this one, too.
Okay, June 15th. What is this?
That's actually when I paid to have the 3 deeds made up. That's the $450 that I had to pay to the attorney for him to make the 3 deeds up. And everything Stacey had to do was sign them.
And that was June 15th. That was not quite a month later.
Right. I started the next day.
Okay. And this is so far what you spent in reliance on her statement that I'll sell you the property for $1,000.
This is a breakdown that I have, that I wrote down, that you can show her that, of everything, the timeline and...
I don't need a breakdown of the timeline, sir. I need the bills for this, not what you wrote.
Okay.
I need the bills for 6 tons of gravel. That was in July.
Here's one receipt right here. There you go.
Did he ever give you $1,000?
He never paid me.
I'm a common sense person and a property owner. It was overreaching to think that you could buy a piece of that land for $1,000. Overreaching.
Julian Hall claims his neighbor, Stacy Benedum, owes for building costs and attorney fees. Stacy is countersuing, claiming Julian was illegally parking on her property.
Okay, so far all I have that you paid was $450 for the deeds, $800 for the survey, and gravel to be delivered.
I got the gravel in there. I also have the concrete that I had laid, flowers and stuff that I put in.
Did he pay part of having the tree stumps removed?
We split the cost and the labor of removing the debris of the trees.
No, ma'am, that's not true.
Who wanted the trees removed?
I never had a problem with the trees. I like the trees.
Don't speak.
He wanted the trees cut down so he could have more space. He was already parking underneath the trees with a smaller trailer, just not his truck. He wanted more space, so he came to me and said, hey, what if I split the cost of the cutting of the trees? I said, that's fine, I'll split the cost, that's fine with me. And then I agreed to let him continue to park there as long as there was no tire marks. That's what it was. And then he built this thing.
Well, he formalized parking there. Mm-hmm. Okay. At what point did Miss Benedum tell you that she was not going to sell you the property?
This actually started on 4/3 of 18.
I'm not interested. I'm interested in the beginning of these texts, where you clearly had discussions. Trees were removed. I don't quite understand why she allowed you to remove the trees, and I don't understand the whole transaction.
Because it wasn't my choice.
Just a second. It was your choice. You wanted to park there. That's what you wanted.
But the trees was dying.
I don't care if they were dying. I don't care if they were shriveled up. I don't care. You carved out a piece of property. Now, if you carved out a piece of property that belongs to her and you didn't have an appropriate agreement in writing, which it has to be, then I believe, based upon her statement that you acted on, you're entitled to whatever you spent to renovate that property. Do you understand? You're not entitled to the property.
No, I understand.
You're not entitled to the property. You're entitled to what you spent to renovate the property. So now I want you to tell me, on what date did she tell you that she was not going to sell you the property?
That was 7/20 of 21. After I got everything done and called her and asked her, could she meet me at the bank? She said, no, I'm not selling to you for $1,000. But it goes deeper than that. That's what I'm trying to explain to you. It goes deeper than that, because when it came to the trees, I didn't approach her with the trees. She came to me and said, since the tree was dying, I said, well, I'll go in half with you. At that point, I said, when can I use the property? She said, you can use it as long as you need it. So that's when I started investing all this money into the property.
So what? I don't care. She said to you, you can use it as long as you want.
Yes, ma'am.
Okay.
I said nothing permanent.
She said, as long as I need it. That's why I invested the gravel.
Okay. What I'm telling you, sir, is the purchase and sale of property has to be with a certain formality. If you dealt with an attorney, the attorney would tell you that it had to be in a formality, signed by her, signed by you, a contract that provided for sale, when it took place, what the survey was, whether her bank would agree to let her sell off a piece of the property because you have a mortgage, all of those things. That's why agreements to sell real property, which is land, have to be in accordance with a certain set of rules. This doesn't make it. However, if you relied on her statement in order to improve the property, to make it comfortable for you based upon her text message, I believe that you are entitled, based upon the text message, to what you spent to improve it. But you have to understand, she's not going to let you park there anymore.
And I'm okay with that.
Just a second. Are you still parking there?
No, ma'am.
Since when?
I would say September of 2022.
So you were parked there in July of 21, August of 21, September of 21, October of 21, November of 21, December of 21, January of 22, all the way up to September. You were parking there.
This is because we had...
Don't give me a because.
No,
that's either a yes or a no.
I was parked there, but we also had a civil case, too.
Which he dismissed 2 days before.
We had a civil case. She called the police.
He called the police on me twice.
The question was, when did she tell you she wasn't going to sell you the property?
September, when she agreed not to meet me at the bank. That's when she told me she wasn't going to sell.
September of 2022?
Yes, ma'am.
I never knew we were meeting at a bank.
Just a second. So
I can do better
in
than that.
September of 2022, she advised you.
No, I'm sorry, it was August of 2021.
Well, show me in August of 2021 that you told him you weren't selling him the property.
Here's.
Okay, I'll take both, Kevin. Thank you.
And this was after she agreed.
Shh. Okay. I'm just looking for the date on this.
Yeah, there's not a date on there, I'm sorry, but that was after May 18th of 2021. That was maybe July or August of 2021 when I told him, since he didn't meet all the requirements, that I no longer want to sell it.
What requirements?
He never met the requirements of paying me the money or getting the land appraised. The only thing he didn't do that my mortgage required is the appraisal.
Ma'am, that wasn't true, because I did everything that the city of Akron told me to do, who deal with this on a regular.
Did you get an appraisal?
I got the land surveyed. She didn't tell me about nothing about appraisal until after I got everything done.
That's why you have a contract in writing for the sale of property, sir. I don't think you did anything intentionally wrong, but there was an appraisal that was necessary. Clearly, if she has a mortgage and a bank is giving her a certain amount of money on a parcel of property, and she wants to sell off a piece of that property, the bank is going to want to know how much the value of the property has diminished by her selling it to you. So you have to have an appraisal. Do you understand?
I understand that.
Okay, and you didn't have an appraisal. I'm not going to tell it to you again. And all I want to know is when she first told you that you didn't have a deal. So once she told you that you didn't have a deal, whatever else you invested in this property was on you.
No, and I didn't invest anything else other than getting an attorney and paying everything I needed to pay him.
Once she told you that she wasn't selling the property to you, what'd you need an attorney for? You're not the aggrieved party here. You got to park for free because she was a good soul. I would have had your trailer and your truck towed to an impound on day 2.
Julian Hall has accused his neighbor, Stacy Benedum, of breaking their agreement. Stacy claims there was never an agreement and is countersuing for parking fees.
Once she told you that she wasn't selling the property to you, what'd you need an attorney for?
Because I had already had an investment after she said she was going to sell it to me. Once the attorney got involved, he told me to dismiss the case. Then after that, like 3 days later, I moved off the property.
Just a minute. So who brought a civil case?
I did.
When?
Last year of 21.
And what happened with that case?
It was dismissed.
What did you bring a case against her for?
For breach of contract.
It was dismissed because there was no contract.
Your Honor, can I say something?
What?
He made all these improvements in 2018 before we ever discussed selling the property.
You mean he put the gravel in?
Yeah.
Well, how could he put the gravel in over trees?
The trees were cut down in 2018.
Is that right, sir?
That's correct.
The trees that were cut down in 2018, well before this.
Yes.
So you did use it. You used it for how many years? You used it 18, 19, 20, and 21. You used it. You used it. You had value from it. You had value from somebody else's property. You used her property for you to park on. You can't.
I wouldn't have done none of this if she would have told me no. Every move that I made, I asked her first. I got it in text message. I asked her, can I do this? Can I do this? She said, yeah, go ahead and do it. If she would have said no, I wouldn't have done none of it. I wouldn't have put a dime into the property.
I'm not going back to 2018, sir. If you made these improvements in the property in 2018 or 2019, before there was any hint of a writing that she was going to sell you property.
She had a verbal that I can park there as long as I want.
Damage after his car was vandalized.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2151, Martin versus Morale.
Thank you.
You're welcome.
Mr. Martin, you and the defendant are neighbors.
Yes, ma'am.
How long have you been neighbors?
Moved into the subdivision in 2019.
That's how long you've been there?
Yes, ma'am.
Do you know how long the defendant has been there?
I think 2014.
Is that right?
2017, Your Honor.
Oh, okay.
And where do you live in respect to one another? You want to go over there and show me?
I live in this house right here. Or I did. I don't anymore. This house right here. And she lives right here.
You sold your house?
Yes, ma'am.
Okay, and the defendant
She lives right here.
Where the blue car is?
Yes, ma'am.
Okay, thank you. This is sort of a circular area, and from the circular area, you pull into your driveway. Is that right? Okay. It is your claim that the defendant keyed your car.
Yes, ma'am.
And when did this happen?
January 22nd, 2022.
The defendant says that she did not key your car. She has a counterclaim. She claims that she was falsely arrested and held overnight in jail.
That is a lie.
But just a
Okay.
That's her claim, that she was falsely arrested, that she spent a night in jail. She had to hire a lawyer, did hire a lawyer after her lawyer requested several adjournments. You were not, at least physically, in the courtroom at the time of the last adjournment, and the case was dismissed. So let's go back to prior to January 22nd. I assume that if you're alleging that the defendant keyed your car, that you have some negative history with each other.
Yes, ma'am.
Starting when?
there are so many. I mean, it started out when we did the subdivision. They were nice at the beginning, no issues. And then the kids started having, her granddaughter lives with her.
Okay, how old's your granddaughter?
She's 9 now. She was 8.
Okay.
They started out having some issues, as kids do. I mean, you know, that happens.
You have a child of a similar age?
Yes, ma'am. She's 11 now. She was 9 or 10 when we lived there.
And the 2 children had an issue?
I mean, you know, kids argue.
No, I understand that. I'm not going into who was right and who was wrong in the kids' argument. I don't really care. But when did that argument between the 2 children spill over to the neighbors?
Well, I guess the final straw was Labor Day weekend of 21, the Sunday before the Labor Day. We came home late. It was about 7 o'clock. We were working, and we told Jillian we were going home for a little bit, and she said, I want to swim in the pool. I said, all right.
Jillian is your 10-year-old?
Yes, yes. And of course, she said, well, that's boring, Daddy. I want a friend to swim with me. So I said, okay, 1 friend. That's it, because your brother's going to watch you, and then we're leaving to go back to work. So she goes next door to Patrick's house, which is the next door neighbor, and she asked Patrick to come over and go swimming. He comes over. At the time, I didn't know this. At the time,
At the time, the defendant's granddaughter was there.
Yes.
At Patrick's house.
Yes.
Got it. So your daughter went over and invited Patrick to come and swim.
Right. And not
You had told her that she could have 1 friend in the pool, so Patrick left to come swimming, leaving your granddaughter alone.
Well, she had to go home.
She had to go home.
Yes.
She came home.
So just a second. Okay. That's what happened. Okay. You had a grandchild who had hurt feelings. I assume
she actually went over to go swimming. She thought she was invited too.
You had a child with hurt feelings.
And I went to ask what had happened.
Okay.
That's this big hoopla.
Okay. Now, your grandchild comes home. I assume she was upset. Was she crying?
Yes.
Okay. And that was about what time?
In the evening. I honestly can't remember.
Okay. And when she came home crying, tell me what you did.
Went out and, honey, what's wrong?
What did you do?
Are you okay?
Yes, and she told you what happened.
She said, I went over to Jillian's. She invited us swimming. And when I got there, her dad said only 1 person could swim.
Okay.
So she came home.
Okay, and what did you do next?
That's not what happened.
I talked to her, calmed her down, and I went over and said, hey.
You know, just a second. You walked from your house, where the blue car is.
Yep, around the corner.
Did you take your granddaughter with you?
No, ma'am.
Okay.
She's lying.
And what? Shh. If you do that again, I'm
All
just going to dismiss your case. Do you understand that? And you know, it's easy.
I got it.
This isn't my case. It's your case.
I know.
So you walked alone to his house. Did you knock at the door? Did you go outside? I want you to tell me exactly what you did.
I don't remember if I went to the front door, if I went to where the pool is, and I do believe Mr. Martin was out there.
Okay, so Mr. Martin was out there, and you said it in that kind of a calm tone?
What happened to my granddaughter? Why is she crying?
Well, she told you why she was crying when she was home. She told you she was crying because she went over there to swim, and Mr. Martin said you can only have 1 person swim with you.
Which is totally out of character. The children swim together all the time.
You mean at Mr. Martin's pool?
At Mr. Martin's pool, and if they need another adult.
Just a second.
I go.
So they swim all the time in Mr. Martin's pool, so you wanted to know what happened on this occasion when he said only 1 person can swim.
Yes.
And you said it in just the same kind of conversational tone that I'm talking in, is my question.
I was very calm at the beginning, yes.
Oh, okay. And so you said to him what happened, and what did he say to you?
I don't remember exactly. It was to the effect of his son was going to watch them, and he could only have 1 child in the pool.
Right, that he wanted his son to have responsibility of only watching 1 other child other than his sister.
Correct.
Right, well, that sounds reasonable.
And that's fine.
Just a second. So how did it escalate? He said, I only wanted 1 child in here. My son's going to watch the kids. We have to go back to work. And that should have been it. Why wasn't it?
I don't know.
So I walked back out and looked at the Pathfinder, and that's what I discovered, the scratch across the back. Bright white, so that indicates it's fresh. I told her while she was standing there, you're going to jail. I'm going to call the police.
Okay, now I'd like to see the video.
Zachary Martin claims his neighbor, Nancy Morrell, keyed his car and owes for the repairs. Nancy is countersuing for a false arrest. and lawyer fees.
Now let's get to your version of what happened. Okay, so you said only one child. Her granddaughter went home. Her granddaughter, who's a little girl, is upset. Why can't I go swimming too? I got that. And?
This is a lie. Everything she told you was a lie.
Just a second.
She did not come to my house.
Just a second.
She did not come to my house.
If you say again it's a lie, I'm going to dismiss your case. Do you understand that?
Yes.
I asked you what happened.
She did not come to my house.
Okay.
Her daughter came to my house.
Just a second. You mean her granddaughter's mother?
Yes. I never talked to her.
Before my daughter went over, I had gone over.
She didn't.
Oh, no, just a second. Yeah. Now I don't believe you, Miss Morrell. Now I don't believe you, madam. I watched your eyes. I just watched it. Now uncross your arms. So, her daughter came over first.
No,
Yes.
I
Well,
went
she
over.
never-
I don't want to hear you.
She never came over. The daughter came over. She bypassed my front door and went to the side gate where the pool is. She told my son to go get me.
To go get you?
To go get me. I came out and she called me a jerk. You should let her swim in the pool. Blah. I just told my daughter, look, you can have one friend because your brother's watching you. It's not fair for him now to watch 3 kids. Just 2, that's all. I told her, I said, look, I don't know what you're talking about. I said she could have one friend and that's it. She proceeded to call me a jerk. She said some other choice words I'm not going to repeat, in which case I did cuss her out and told her to get off my property and not to come back again, anybody in her family, or I would file trespass charges.
Okay, and that was on the Sunday before Labor Day?
Yes, ma'am.
And when did this incident happen with your car?
January 22nd.
After that incident on Labor Day weekend, did you have any other contact with the defendant?
Yes.
When?
So I think it was right after Jillian's birthday on November the 21st. I think it was like a week, like December the 1st, I think. And this is really sick, but it got to the situation where she would watch my kid. And every time my kid would go to Aubrey's house or Patrick's house, she would take toys, she would unpack her stuff. And I told her, I said, look, you can't play with her. So they would wait 10 or 15 minutes till she got unpacked and get all comfortable, having a good time. She would send her granddaughter over there. She had to pack her stuff up and come home. She would come home crying many times. So then it got to the point where Patrick, he would come over to our house. He'd be over to our house all the time. They would get on trampoline, play video games, blah, blah, blah. So I was doing something one day and then the camera went off and I give me a load of my iPad. Here comes Nancy up my driveway. She knocks on the door and she says, can we play? And I said, no, you can't play. Get off of my property. File trespass charges if you come back. That was, the last time I interacted with her. Until she keyed the video.
Well, it's not my job to be judgmental in a social way, but I have to tell you, I would have handled it a little differently with her. She wasn't the one who behaved badly. I wouldn't visit her daughter's bad behavior on an 8-year-old. There are kids who live right around the corner from each other, and it seems to me that the bad behavior of a parent or a grandparent shouldn't impact on a child. The granddaughter is a nice little girl.
Well, I mean, if you say so. I mean...
Is she?
Well, she spread rumors about my daughter and said that, she told Aubrey that my daughter stole some of her toys, and that was a lie.
Okay. All right. Well, it sort of started to get nasty. Now let's get back to the keying of the car. So that happened in January. So tell me about the January incident.
Okay, so she got up January 22nd. It's a Saturday. She decided to walk her dog. She's walked her dog.
Go over there. Show me what you saw.
Okay. So she decided to walk her dog, and so she walks up the sidewalk.
Well, you didn't see that.
No, not right here.
No, you didn't see that.
When she gets about right here, which is Patrick's house, the mailbox is right here, you can see in the video. That's when the cameras detect motion. That's when I get the alert. So I see her walking the dog, and she's walked her dog past my house many times, but never gotten that close to my vehicle. So immediately I thought something.
Where was your car?
My car is parked right here.
In the driveway?
Yes, ma'am. So she walks the dogs, and she is right beside the view. I mean, you can see in the video, you can see her right hand go up. So I immediately run out of the house. I have a truck parked right here. I looked at my truck. I thought maybe she did something to the truck. I looked at it, didn't see anything. I went back outside and I said, well, wait a minute, let me go back outside and look at the Pathfinder. So I walked back out and looked at the Pathfinder, and that's what I discovered, the scratch across the back. It's bright white, so that indicates it's fresh. I told her while she was standing there, you're going to jail, I'm gonna call the police.
Okay, step back. When you said to her, you're going to jail, I'm going to call the police, did she respond?
I don't think so, no.
Okay, now I'd like to see the video.
Okay. You can see as her hand goes up right there.
I'll take a look at it again. Is there any reason that you stopped behind his car? Is there any reason?
Stopped to sniff, I stopped with him.
You see her right hand right
there.
I'm moving my arm as I walk.
Yes, and that's where the scratch is.
Okay, can I take a look at the photographs of the scratch, please? Okay, so based upon what you saw, you called the police. And based upon that, the police came, interviewed you, and viewed this tape.
Actually, I had contacted the police after he had yelled at me. He's a little incorrect. Could I show you where?
Sure.
I did walk my dog around here. His cars impede the sidewalk, so I moved. And I had completed my whole route over to about here, and he did indeed come out and yell at me. I caught a few words of it, said I'm walking my dog, waved my arms, and continued on. That's not the first time he has yelled at me as I've been walking, and I went home and I filed an incident report, and I do have that.
Just a second.
The second time I've been walking and he's come out and yelled at me, it's very unnerving.
That's a lie.
We're very far.
Sorry.
It's going to cost you getting your car fixed. It's something you don't understand.
I have it.
Something you don't understand. I'm allowing both of you to tell me your sides of the story. You can't say that's a lie. Do you understand?
Yes, ma'am.
I'm not cutting you off. I let you tell me your story, sir. I let you tell me what happened, and I want to give the defendant the same opportunity. You can't interrupt her. Now you understand that?
Yes, ma'am.
Okay. I will tell you what I don't understand, Miss Morell. You see, if I had got into a kerfuffle with him, which you had, because he said you and your granddaughter, which I actually think was socially wrong with regard to your granddaughter, but with regard to you, he doesn't want you there, right? I wouldn't walk up a cul-de-sac to go past his house. If it were me, I see plenty of space where you can walk. You can cross the street from your house and walk in the street the other way. And then when you come back, you can walk the other way. You don't have to go inside that cul-de-sac to walk anywhere near his house. That's looking for trouble.
Can I just say something?
About what?
The trend that another gentleman, he tried to accuse of scratching his car.
Are you her husband?
Yes, ma'am.
Okay, I'm going to let you stand up now, and you're going to show me where he accused somebody else of keying his car in the back in January. Show me.
Zachary Martin is accusing his neighbor, Nancy Morell, of keying his car. Nancy is countersuing for a false arrest and lawyer fees.
So you have a counterclaim, and your counterclaim is for false arrest. He didn't arrest you. The police arrested you. And the police arrested you based upon what they believed, after looking at that video, was probable cause that a crime was committed and probable cause to believe you participated in the commission of that crime, which is vandalism. He didn't make a citizen's arrest. The police made an arrest. And not only did they make an arrest, but they were serious enough to have you get a lawyer. Your counsel went in. I assume your new counsel asked for an adjournment. I assume your new counsel, you were there.
I believe so. I was not there, ma'am. I waited out in the hall, and my lawyer represented me.
Fine. So I assume that you knew that your lawyer was going to ask for an adjournment. The lawyer didn't prepare you for trial, did he?
No.
No.
Your Honor.
So he was. I'm not listening to you.
As a witness, can I just say something?
About what?
The trend that another gentleman, he tried to accuse of scratching his car. We have evidence of that.
Just a second. That I'll listen to in a minute.
Okay.
The second time your case was on, did you go into court or did you wait outside?
I waited outside.
Then if you waited outside, you knew again your lawyer was going to ask for an adjournment. The first time the case was on, did you attend the court hearing?
Yes, ma'am.
Were you inside the court?
Yes, ma'am.
She was not there.
She was outside. Yes, ma'am.
The second time when the case was adjourned, were you in court?
Yes, ma'am.
Was she there?
Yes, ma'am.
Outside or inside?
She was outside.
Did her lawyer ask for an adjournment?
Continuance.
A continuance?
Yes, ma'am.
Same thing?
Yes, ma'am.
Did it happen more than twice?
Yes.
On the third time you went to court, did you go to court?
Yes, ma'am.
Was she in court?
Yes, ma'am.
Inside or outside?
She was outside, and what happened, I had sold the house, and we moved an hour away.
Just a second. You were there.
Yes, ma'am.
Okay, now, I'm going to let you stand up now, and you're going to show me where he accused somebody else of keying his car in the back in January. Show me. No. Well, this says that on January 18th, which was 4 days before this incident, you reported another vandalism to a Nissan Titan.
Yes, ma'am.
Is that the car that you saw her key or believe she keyed?
No, ma'am, that's a different vehicle.
That's what I thought. That's a different vehicle. That has nothing to do with this car.
Well, the gentleman that he accused of, he didn't even have arrested or didn't want to press charges.
Just a second. Okay, so now I'm going to let you stand up, and I'm going to give you my end of the riot act, because if this is what you're deluding yourself with, I'm going to tell you. He didn't have video of anybody on the 18th around his car. In your wife's case, sir, he had prior experience with her. She had no business walking right in front of the house when there are plenty of other places to walk. If they are not on great terms, he had every right to call the police, show them the video, and they had every right to arrest her. Do you understand that?
I understand that, but
Good.
that doesn't
This has
prove
nothing.
that she scratched the vehicle. That doesn't prove that.
Just a second. That's what a trial is for, sir. That was up to a jury. What your wife is suing him for is for false arrest. He didn't arrest her. The police arrested her. Now sit. May I see the invoice? Have you had the car fixed?
Yes, ma'am. I have an estimate, and I also have the police report. where
I'd like to
read
see
her own
both.
words.
I'd like to see both. So the police officer indicated that after you were told about what the officer saw on the video, you've decided to make no more statements about the incident, and you were placed under arrest for malicious damage. The officer also reported that the scratch on the back of the car was fresh because there were fresh paint chips on the street that were red paint chips. There's a red car that came off that car, which demonstrates to the eyes of any layperson that since there's traffic back and forth there, if there are fresh scratches and fresh paint, it means it just happened. So your counterclaim for false arrest and anything attendant thereto is dismissed.
I did not do it, Your Honor.
Right, well, okay, maybe the case was dismissed. That doesn't mean you're entitled to money from him. Police had probable cause to believe that a crime was committed and probable cause to believe that you committed that crime. The rest of it is up to a jury. So you have a beef with the police department, not with him. They had an absolute right to arrest you. I'm not giving you $2,500 for this scratch, sir. Get it out of your mind. Do you understand?
Why not?
It's not a $2,500 scratch.
I mean, that's an estimate from a
$500. Judgment for the plaintiff. We're done.
This court is adjourned.
Well, she was incorrect because I did not do it.
You know, we took an oath when we went inside to tell the truth, and she lied repeatedly, and she got mad at me when I said that's a lie, but it was a lie.
That he saw me walking by and looked at the car and said, oh.
The next day I called the police to see what happened, and they informed me they arrested her.
I thought they were there because I had called about him harassing me, and then all of a sudden they just said, you scratched his car. And I said, no, I didn't.
I think she should have stayed in jail longer.
They placed me in custody.
The lady does nothing but lie. She's a liar.
It was horrible.
I actually thought his behavior when the defendant brought her granddaughter over subsequently and said, can't she play? Because evidently there are 2 or 3 kids who live close by and they always play together. All of a sudden, the granddaughter is excluded from that play. There's a certain amount, as a parent, he should have had some sense of that and said, well, of course they can play, but your daughter owes me an apology. You know, if you're behaving like an adult, your daughter owes me an apology. I tried to do a responsible thing. I didn't want to let my son watch more than one stranger child in a pool, which is absolutely smart because, God forbid, something happened to one of those children, they would certainly turn around and sue him.
Yeah.
So he did the responsible thing. Was it hurtful to the other child? Yes. According to him, his daughter was playing at Patrick's house. She came over and said, you can't come. Because they're little children. They don't understand. You can't come. Only one person can come. But you're a grown-up. So understand how that could be hurtful to an 8-year-old. Anyway, I think that they both behaved badly. And he's very smart to have moved out of that.
Out of the cul-de-sac, out of the
cul-de-sac. Yeah, could you understand why she would walk her dog there?
Yeah, I agreed with you that if you've already had even just a hint of distaste with any of your neighbors, I just walk on the other side of the street, just avoid it. And this seems like a perfectly avoidable house in the cul-de-sac.
You actually have to
go into his loop in order to make the loop. So I don't know. I think both sides questionable, but I'm glad that he got something that you were willing to give him for his car.
Yeah, get your car fixed reasonably. And the police absolutely had a right to arrest her.
Yeah.
There was a complaint. They looked at the complaint. They saw the damage. They saw it was fresh. They saw her right there on the video. They had a history of bad feelings between them. They had an absolute right to arrest her.
Yeah.
Too bad. I feel sorry for the little girl.
Suing her ex-boyfriend, James Stewart, for travel costs and a loan.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2102, Peterson versus Stewart.
Thank you.
You're welcome.
Ms. Peterson, you and Mr. Stewart met online?
Yes.
You met Mr. Stewart, and according to your complaint, a romance developed, and there are two things that you believe, now that the romance is over, that he owes you. One of them is a loan that you made to him for $1,000. Now, Mr. Stewart does not deny that you gave him $1,000, correct?
No, ma'am.
Your defense is that it was a gift.
Correct.
And not made as a loan. Okay. On what date did you and Miss Peterson start to date?
We never dated. We actually wasn't through no dating site. Just somehow, coincidence, we came through.
Did you see her?
I met her once in person.
When?
When she paid for a hotel for my birthday.
Give me the date.
January 30th.
Of this year?
Yes, ma'am.
So you met for the first time in January of 2022. Tell me about the $1,000. If you're playing with your papers, you're not going to hear where we're going. Okay.
The $1,000 at that time, I was been struggling with heart disease, which I just got out the hospital for having a heart surgery last Friday. So financially, my dealership was a little bit under the burden. So I asked her if she would help me.
And when did you ask her? Was that in January?
No, ma'am. That's a couple months later.
All right. So that would be in March.
Yeah.
And the only time that you ever met her was in January.
I met her once, other than that, when she gave me the money. Other than that, it was just normally her texting me, how you doing? Do you want to meet up?
Okay. So you met personally twice.
Correct.
And after January, you didn't see each other personally, just by messages. And that's when you asked her for money. And you were going to tell me why in March you asked her for money. I understand that you just recently came out of the hospital, and while I'm happy to see you looking well and healthy, it's really irrelevant to this case.
Yes, ma'am.
Okay, so why did you ask her for $1,000?
Because she offered to help me.
No. Nobody offers to help you unless they know that you need help.
Well, it's in writing.
No. Nobody offers to help you unless you let them know that you need help.
I was kind of life coaching her. We both was going back and forth. We had an open line of communication, so I kind of got comfortable to ask. So I see what you're saying.
Got comfortable to ask?
She already gave me money before that $1,000. That's why I was comfortable.
Just a second. I'm talking about the loan. I want you to tell me, since you acknowledge that she gave you the money, tell me why you needed it.
Well, I needed it because I paid for the trip, which was $2,180, which she gave me $2,000 plus $160 more for luggage. Came to just shy of $2,400.
I don't understand what you're talking about.
Well, she's already came to me and gave me money for us to take this little trip together.
What does that have to do with this $1,000? That's not what I'm talking about.
Because she was supposed to come and reimburse some of the money because I paid already into the trip. So I was asking her for money.
Am I crazy? Did he start to talk about his business needing money? He has a used car business.
Yes.
Really, before you come on a program like this, you should really watch so that you would know that one of my favorite sayings is, if you tell the truth, you don't have to have a good memory, especially if you're smart. Now, if you're not so smart, and within 3 minutes you tell two different stories, that, Mr. Stewart, is a phrase that you should learn to live by. If you tell the truth, you don't need a good memory.
That's not correct, Your Honor.
Well, that's only because you wouldn't know the truth, because you have been introduced to the truth.
He says
The $1,000 at that time, I was struggling with heart disease, which I just got out of the hospital for having a heart surgery last Friday. So actually, my dealership is a little bit under the burden, so I asked her if she would help me.
So you remember saying that?
Yes, ma'am.
Okay, so that's different from she was paying me back. You just have to acknowledge that's different. Okay, and let me tell you what you swore to in your answer. She offered to help me catch up on my child support.
On a phone conversation, yes.
I just asked you one simple question, sir. You acknowledged she gave you $1,000. What was it for? So now I have 3 reasons. 1, your car dealership was a little bit of a burden. 2, she was returning your money to you. And 3, you were catching up on your child support. Yes. Those are the 3 things that I have in front of me.
Yes, ma'am.
Is it door number 1, door number 2, or door number 3?
Whichever one you would like, ma'am.
So far it's $1,000 for the plaintiff. Now, whether it was for school or whether it was for your children's support, she's not responsible for your children's support. You're responsible for your children's support. Have you ever met his children?
No.
She doesn't even know your children.
No.
Do you have a child support order?
No. She asked me to marry her, though.
Just a sec. I asked you a question,
yes,
not
ma'am.
her. Do you have children? The answer is
yes. I have children, yes, ma'am.
Yes. This is not a dance.
No, I'm just
This
saying.
is not a dance.
Yes, ma'am.
You lead, I lead, I always lead.
Yes, ma'am.
Later.
You had some trouble with your finances, and you had serious debt. What kind of work do you do?
I'm a credit collections agent.
Not a good thing when you're a credit collections agent.
Joy Peterson claims her ex-boyfriend, James Stewart, owes for travel costs and a loan.
Now, the children do not live with you.
They're above age. Yes, ma'am.
When you swore in your answer that you had gotten behind in your child support order, what child support order was that?
It's the last child because I got behind because I was out of work. So they're above age, but I owe a little arrears.
Okay, so that's the child support that you were behind. Had you been noticed to come to court on those arrears?
I've never been in contempt, no, ma'am. I've always kept a good standings with them.
Okay, but you're behind now.
Yes, ma'am.
You were behind then in March.
Yes, ma'am.
Okay, and you knew you were behind because?
I was on bed rest for 5 months due to a knee surgery and some heart issues.
Okay, did you request that your child support order that was on arrears only be stayed while you weren't working?
I got a new caseworker, wasn't willing to work with me at that time. So.
Okay, so there was difficulty. Your caseworker was involved in this child support order. That sounds better. And the child support order was in favor of the state?
I don't owe the state no money. I paid all fees off with them. I just owe the back child support.
To the mother of the children?
Yes.
Okay, $1,000. Now, I'm going to come to you. According to you, you gave the defendant $2,000 to buy travel tickets for you.
Yes, Your Honor.
When?
I gave him money in March.
At the same time that you gave him the $1,000?
No, ma'am. That was in April.
Show me proof of that. And I want to see $2,000 taken out from someplace for him to pay for these tickets. And they were tickets for you to go from where you live, which is where?
Springfield, Ohio.
To Miami.
Yes, ma'am.
The $2,000 was in March. What were you going to do in March?
In March, I gave him the $2,000 to purchase tickets because I asked him, can you get discounts for us to go to Miami because I was going to have surgery. So he told me yes. Sure, so I gave him the $2,000 for that.
That's not.
Then he said, well, that's going to be more than that. I said, well, that's all I have for the tickets for me and my daughters. He said he wanted to go, so he was planning on going.
Mr. Stewart.
Yes, ma'am.
On what date did she give you the $2,000 to buy the tickets?
It was early March. She could.
Yeah, March, looks like March 25th. She gave you $2,000. And when were you supposed to go to Miami?
We were supposed to go July 4th, and she.
Okay, just a sec. You're supposed to go in July. So you're talking about 4 months later.
Yeah, she canceled the trip.
Okay. When did she cancel the trip?
She canceled the trip about a month later.
So she canceled the trip in April?
Yeah, and it was a third party, so it's non-refundable.
I don't know that at all.
Yes, ma'am.
Now, just a second. So you're going to have to show me.
I didn't borrow it.
You borrowed the $1,000. I didn't say you borrowed this $2,000. She gave you money for a specific purpose.
Right, she went.
Don't speak. She gave you money for a specific purpose to purchase airline tickets.
For us?
Which I don't give a rat's behind for who. She gave you money to purchase.
As I did.
Airline tickets.
As I did.
This is not a dance.
No, I'm just
This
saying
is
I
not
did.
you lead, I lead, you. I always lead.
Yes, ma'am. Absolutely.
I always lead.
Yes, ma'am.
She gave you $2,000 to buy tickets. That you acknowledge. The trip was canceled 3 months before the trip. Now, you say they were non-refundable tickets.
Yes, ma'am.
Show me. I just want to see where you tried to get either a refund or a credit 3 months. And I don't speak. You have to show me, because you just said the tickets were non-refundable tickets, and I could neither get money back for them when she canceled it or a credit. And I said, in all that paperwork, show me.
It's just public knowledge on their website. I apologize, I do not have it.
It's not public knowledge on any website. Judgment for the plaintiff in the amount of $3,000. $1,000 loan, $2,000 for the tickets. We're finished here. Thank you very much. Out.
This court is adjourned.
Out.
She wanted to go on a vacation.
Taking advantage of me.
She was being a little aggressive.
Don't even look that way.
Now, hopefully, we could just move on with our lives.
I think we should print that on cards to hand out to people as they leave here. If you tell the truth, you don't have to have a good memory.
Yeah, that was pretty funny.
That defendant, in the first 15 seconds, told 3 different stories about the same $1,000. Reminded me of a toddler when you ask if they had cookies and it's all over their mouth and they say, no, I didn't have chocolate, I didn't have candy. 15 seconds, 3 different stories. So if you tell the truth,
you don't need a good memory.
Not at all.
Case 2158, Smith versus Crosley. All parties, please step forward.
Justin Smith is suing his ex-girlfriend, Jessica Crosley, for an unpaid loan.
Miss Crosley, I'm going to start with you. You and Mr. Smith were in a romantic relationship for a period of time.
Yes.
From when to when?
I want to say it was about a year before my son was born. My son was born February 11th, 2019, and our relationship ended about 4 or 5 months after he was born.
And after you separated, according to what I read, you sort of remained friends.
Yes.
Great. You had some trouble with your finances, and you had serious debt. What kind of work do you do?
I am a credit collections agent.
Not a good thing when you're a credit collections agent. And this was after you had already been separated for a long period of time. And at some point, what I'm piecing together is you discussed your financial circumstances with Mr. Smith.
Yes.
And one of your options was to seek protection in bankruptcy.
Correct.
And Mr. Smith thought that that was a bad idea.
Yes.
So he suggested that you take out a loan, consolidate all this debt, which was on, I assume, on credit cards with very high interest. And since he had credit, he would take out the loan and you would pay that loan off, which was manageable every month. Is that generally what this is about?
Yeah.
Yes.
His behavior had started getting irrational, scary, started calling me a lot, asking my whereabouts, texting me, driving by my house on several occasions I saw.
I'm still not understanding why you stopped paying on the loan.
Justin Smith claims his ex-girlfriend, Jessica Crosley, owes for an unpaid loan.
Mr. Smith did take out that loan month and year.
March of 2022, this year.
What were the payments each month, starting in March or April, principal and interest?
He had told me that it was $500.
Told you they were $500. He took out that loan, and am I correct, Ms. Crosley, that you paid off your credit card debt?
Yes.
And you paid off your debt with the loan that he took out?
Yes.
And you did, in fact, create a situation where the money, because you were employed, would come out directly from your bank account to go to pay off the loan to his bank account.
Yes.
And you did that in what month?
That was started, I believe, at the end of April or beginning of May.
And how many such payments did you make?
Biweekly payments, I believe I made about 6.
Thereby acknowledging that this was a loan. At some point, you stopped making the payments. What month did you stop making the payments?
In July of this year.
Why?
So I had started seeing my current boyfriend.
This is not a social show. Just tell me why.
So I had to take a day off of work to file for an order of protection.
Why did you have to take a day off from work to file for an order of protection?
Because I was advised to by a police officer I spoke to.
Okay. And I assume against him?
Yes.
Okay. Give me the incident.
Okay. So in July, when I started seeing my current boyfriend, Justin had expressed that he wanted us to get back together. And I had told him no, that was not going to happen. And then his behavior had started getting irrational, scary, started calling me a lot, asking my whereabouts, texting me, driving by my house on several occasions I saw. And then there was an incident on July 19th where I had allowed his mother to take my son to a play, and she was supposed to drop him off back to me. And instead of dropping him back off to me, she had dropped him off with his father at his work. And then I got a call from Justin yelling, saying, "Where are you? What are you doing right now?" And I'm like, "Well, I'm on my way back home. Your mom's supposed to drop off Braden." He's like, "I have Braden. I'll meet you at your house." So I said, okay. We got to outside my house, and then he pulled up next to me and then started screaming out of the car, like, "Where were you? What were you doing?" I was like, "I was spending time with Anthony, my boyfriend." And he's like, "I'm taking Braden. I'm not going to give him back to you." And my son's crying in the back seat. And I said, "No, you give him back to me. It is my day to have him." And he drove away. He later called me and said I could meet them at Dairy Queen. So I met them there. I got out of the car. I went up to my son. And as I was getting him in the car, Justin had walked up to my car and started yelling and swearing at me. And as me and my son started driving off, he threw a milkshake at my car, which scared me and my son very much.
Okay, good. And you filed for an order of protection. You had a trial on the order of protection, yes. And the judge dismissed your order of protection.
Yes.
After the trial.
Yes, ma'am.
Okay. I'm still not understanding why you stopped paying on the loan.
So when I had lost my job.
You lost your job when?
The next day. The incident happened on the 19th. I had to take the 20th off to file for the order of protection. The 21st, I was let go.
Oh, that had nothing to do with you being let go. Nothing. I just want to know why you stopped paying on the loan. You stopped paying on the loan because you lost your job? Are you working now?
Yes, I just started working.
Well, did you start paying him back?
No. So
why?
Also in July, when all these incidents happened, Justin had stopped paying for daycare, which was our agreed upon child support payment. We don't have a court order for child support, but he had been paying all of daycare. I cover all of his other finances.
So that was an agreement that you had, that he would pay for daycare?
Yes.
Okay. And he stopped paying in July?
Yes. He started only paying half of daycare.
Okay. So let's go back. He started paying for half?
Yes.
How much was he supposed to pay per month?
$560 was the full amount of daycare each month.
Okay. And he had been paying that. In July, he cut it down to?
To $270, I believe.
80.
Okay. So he wasn't completely not paying. He was paying part of it.
Correct.
Tell me why you cut the payments in half, because you have a counterclaim for that.
Yeah. So in July, we started a custody case for full custody of our son.
You're talking in July. Who started the custody case?
I did, Your Honor.
Okay. Did you retain a lawyer?
I did.
Is that case still ongoing?
It is.
Well, then I'm not entertaining anything about the daycare because you have that case in family court. The court there will make a determination as far as future child support and whether or not this daycare should have been paid. So you have no reason for not paying the loan.
I was planning on filing bankruptcy.
Okay, but you didn't. You didn't file for bankruptcy. You did the smart thing. How much is left on the loan?
It's in excess of $12,000 or $11,000.
What interest rate is on that loan, by the way?
36%, I believe. Current balance as of November 30th, $12,631.
How is a 30% loan better than her credit cards?
She had some loans in excess of 800%.
From whom?
Or over 500%. These were online lenders.
Oh, wow. Okay, you have a counterclaim. Harassment, daycare costs is out. Lost wages because you say you had to take a day off to file a protective order and you were fired? Nonsense. Harassment, let's hear it. And don't go back to anything that you told the judge during the hearing that you had where he dismissed your application for an order of protection.
Okay, well, the order of protection.
Okay,
that was...
Just shh. Well, if that's the testimony, it's already been adjudicated. A judge, using the same measure of proof that I would use, dismissed your case. So I'm not relitigating that case. Judgment for the plaintiff in the amount of $10,000. Thank you.
This court is adjourned.
I believe he was angry that I started a relationship with somebody.
I think the restraining order was part of her defense as to why she didn't want to pay me back anymore.
I was ready to file bankruptcy, and he had offered to take it out for me.
You know, at the end of the day, the loan is still agreed upon and still needs to be repaid.
I think that that's a good lesson, that you can't use the court systems and restraining orders to get out of a loan that you have really no excuse for not paying except for you lost your job. And I just think it's tricky. I think that a lot of defendants come in here and think that they can just say, I didn't have the money and so I don't have to pay it. But that's not the case.
What's most interesting to me is these 800% or 500% or 100% interest-bearing loans.
I know, it's something.
Where did that come from?
It's something I've seen recently in the past couple of years. It seems like every online shopping venue now has some form of loan payment or loan offering or sign up for our loan program. And I'd never seen that before. And if you don't read the fine print, you could get stuck in, just like the defendant here, with a lot of those.
Karen Heckendorf is suing her home buyer, Dante Zarzosa, for an unlawful eviction, extortion, and emotional distress.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2156, Heckendorf versus Zarzosa.
Thank you.
You're welcome.
Miss Heckendorf, who is this gentleman?
This was an attorney I hired in Mexico, kind of in the middle of the night when...
He's an attorney?
In Mexico.
Okay.
And my witness.
Okay. So, trying to piece this complaint and answer together. You purchased a home from Mr. Zarzosa?
No, Your Honor.
He purchased a home from you?
Yes, ma'am.
Okay, got it. He purchased a home from you in Mexico?
Yes.
Where in Mexico?
About 5 miles north of Rosarito, maybe 10 miles south of the border.
How long have you owned the home?
I owned the home about 5 years.
How much did you pay for it?
When I bought it was $180.
How much did Mr. Zarzosa pay for the house?
$245.
On what date did he purchase the house?
February the 9th.
Were you present at the closing of the house?
I was.
When you closed on the house on February 9th, how much money did you receive?
I was supposed to receive...
No. You were supposed to receive $245,000. How much did you receive?
I received a cashier's check for $15,000.
15?
$15,000. I received cash, $4,500. And I received the next day through a wire transfer 4.6 million pesos or something like that. I have the paperwork.
Just tell me what that translated to in dollars.
It was $220,500.
Okay. Well, if you have proof to how much the translation of pesos to dollars is, that means that you got a total so far without the down payment. Did he give you a down payment?
Yes, $5,000. I was paid for my house. I was paid for my house.
No, I understand that, but this is the problem. Mr. Zarzosa says that when he took out the mortgage, he increased the amount that he was borrowing so that he had closing costs covered to the extent of, I think, $3,800 or $3,900.
It was a total of almost $10,000.
No.
Oh, $3,900.
That's what I asked you. What's 10,000? 10,000 comes out of nowhere. It was a difference, you said, of $3,900.
Yes, ma'am.
And so he wanted from you the difference.
Well, the realtor gave me...
Not the realtor. He wanted from you...
The realtor told me that. I've never really spoke to Dante except for on February 22nd and the time that he came and looked at my house. But the realtor sent me a fake statement, which I looked at because it's a high school kid's piece of paper, and I said I was not making a refund.
Okay. Well, you have to make a refund if you were paid more for the house than you're bargained for with the purchaser.
That's true.
That's true.
And the bank told me on April 1st...
No, they can't tell you anything.
Oh, really?
If they documented something to you, then I'll read it. But you can't tell me what a bank told you. First of all, banks don't speak. Now, I'd like you to get what Mr. Zarzosa is handing me.
This is from the bank.
Well, I can't read this, but what I can't read is in Spanish, but I can read the numbers which indicate that you received, Ms. Heckendorf, a total of $249,544.22. Let me see.
May I see that, ma'am?
Absolutely.
Because this is what that bank gave me right here. And I did go with my witness to the bank on April 1st, and they told me that
The bank can't tell you anything.
They told me that was the correct amount.
A bank can't tell you. They can give you a document, which I will read, but a bank can't tell you anything.
This is not really a case about this contract.
Yeah, it is. It started this way.
They're saying that that bank sent me the wrong amount of money?
Yes. That's what it says. That's what that says.
That's what this says.
That's what that says.
I imagine anyone can write what they want, but I was not paid the wrong amount of money.
Well, the bottom line of it was, eventually you gave him back $2,800 of the $39,000 that he said that he was entitled to. Is that correct?
No.
Ms. Heckendorf?
No.
You never gave him $2,800?
I signed a contract and gave him $2,800 under duress. He took my dogs and my cat, and he took my property.
I want you to understand what I'm saying to you. When I ask you a question, I expect an answer. You gave him $2,800, and you gave him the $2,800 because he believed and told you that he had taken out extra money in order to cover his closing costs. And you got that money, and he wanted that money back because he was going to have to pay for it through his mortgage.
I have never heard that these were closing costs. This is the first I've heard about closing costs.
Well, I'm going to tell you this. I'm going to
never heard about closing costs.
Stop talking. Stop talking.
Okay.
And I'm keeping it very simple. Okay. You're going to want to keep it very complicated, and I, madam, are going to keep it very simple. So the bottom line is you stayed in the house for free.
Karen Heckendorf claims her homebuyer, Dante Zarzosa, extorted money by keeping her pets in property. Dante is countersuing for false accusations and lost wages.
Good. This is your piece of evidence. Your piece of evidence says that you got $249,544.22.
No.
That's what it says.
No, it doesn't.
Okay, that's what it says. You gave him $2,800. He wanted $3,900. You gave him $2,800. What you're suing him for
He also wanted $2,500.
I'm going to dismiss your case. Okay. It's just as easy for me to send you back to Mexico. Once you closed on this house, according to what I looked at, Ms. Heckendorf, you asked if you could stay in the house because your new house wasn't ready to close escrow. Is that correct? That's a yes or a no?
Yes.
And so you closed the house on February 9th, and he allowed you to stay in the house. When were you supposed to vacate the house?
March the 1st. I paid
that's a date, March 1st. And between February 9th and March 1st, how much did you pay him in rent?
I gave him the money from the casita.
Just a second.
Yes.
That's an amount between February 9th and March 1st.
$2,370.
So that was a month's rent. Is that what you received?
No, Your Honor.
How much did she pay you in rent between February 9th and when she was supposed to vacate March 1st? She would have paid you rent in advance.
Nothing.
Show me proof that you paid him anything for rent on February 9th. Did you ever receive from this agent $2,370?
No, Your Honor.
Well, do you know who he is?
Yes, I do know. That's the realtor that represented both of us on the purchase.
And you never received, this was on February 9th. He acknowledges he signed that he received $1,620 as in for the last month's rent and $750 security deposit, as well as prorated rent of $120. I don't know what prorated rent is for.
It was for the end of January. They moved in a few days before.
Who moved in?
The people that rented the casita.
And that's part of the house?
Yes.
What is that?
I have two houses on the property, the one I lived in and the casita. And Dante gave me an email that if I gave him this money from the casita, that I could live in the front house until March the 1st. I have that
Just a
email.
second. When he bought the house, did he or did he not buy the casita as well?
Yes, he did.
So he bought the casita as well. So it belonged to him. This rent belonged to him.
Only
So
if I
what do you mean?
rented
He's
it.
not giving you anything. If he buys a house and there's another property, he owns that property. He owns whatever rent was due for that property. So what you're saying is, let me cut to the chase. What you're saying is, you claim, he said to you, I've just paid you $250,000 for your house, which includes the casita. Your house isn't ready yet to close escrow. I will let you stay in the house free if you let me keep the money from the casita's rent.
Yes.
Oh,
And I have
fine.
an
So that the
email.
bottom line, don't speak, it doesn't look like you're losing so
And-
far. I may not be finished with you.
And
So
I hadn't rented
you're
the
speaking,
casita.
you're trying to speak over me.
Well,
and I'm keeping it very simple.
Okay.
You're going to want to keep it very complicated, and I, madam, are going to keep it very simple. So the bottom line is you stayed in the house for free from February 9th or 10th until it was supposed to be until March 1st. That was your understanding. You were staying in his house for free.
I didn't have to rent the casita.
I don't care whether you had to or whether you didn't have to. You were staying in your house that you sold to him for free until your new house was ready. That's a yes.
I felt that.
I don't
but
care
I guess
how
if
you
you want to
feel.
look at it
I
that
don't
way,
care how you feel.
Okay.
You sold him your property and you took advantage of a piece of that property, the casita, in order to negotiate yourself a free 3-week rent until your house is ready. Now, you may stand there and look at me in that smug way, but you and I both know that that was a deal you made for yourself.
Yes, I agreed.
Okay.
I agreed to rent the casita ahead of time before I moved out and give him the money so that I could stay in the property until my house closed escrow 1 week.
Pretty tricky.
May have been March the 6th.
Pretty tricky. Bottom line is you stayed in his house for free.
Okay.
And then what the rest of the case is about is that you claim that he changed the locks on the door before March 1st, and in the house you had your pets. And he held ransom your pets until you gave him what turned out to be $2,800. That's your complaint. He changed the locks on February 28th. Where were you when he changed the locks?
February 22nd.
22. Where were you when he changed the
I was
lock?
in my office in San Diego.
Okay. And how did you find out that the locks were changed on the door?
Dante sent me an email that I found later admitting to what he did, but
I asked you a question.
I was at my office, and he called me on the phone, and he said, this is Dante Zarzosa, and I have...
My way.
Mm-hmm.
He called you in the office. That's how you found out he changed the locks. That's an answer. Approximately what time did he call you in your
It
office?
was about 6:30, 6:45 in the evening.
6:30 p.m. And tell me what you claim he said to you and what you said to him.
This is Dante Zarzosa. I have your 2 dogs. You're never going to see them again if you don't pay me $3,900.
Now, that wasn't the first time you had heard about this $3,900. That was not the first
time. I heard about it on February the 9th. No, the 8th. Sorry, February the 8th, I'd heard about it.
And so you told him after that you would, or you told him, or you told your lawyer, is that you? Now you can stand up.
I met him...
Shh, don't speak.
Okay.
On what date did you get your pets back?
Well, I didn't actually get them. My friends went and begged for the animals.
Don't tell me what they did.
They gave them to... And they gave them to my...
Stop, please.
Sit.
Karen Heckendorf has accused her homebuyer, Dante Zarzosa, of extortion by threatening her pets. Dante claims Karen owes him for making false accusations.
Your last name, sir, is?
Mena, Your Honor.
Mena. Mr. Mena, you're an attorney in Mexico?
Yes.
Okay. Are you a real estate attorney?
Yes, civil attorney, real estate as well.
You understand what this is about, and you understand if you're a real estate attorney that sometimes people take a mortgage that's beyond what they need in order to cover their closing costs. You understand that?
Yeah, absolutely.
Okay. It's not an unusual thing. I bought and sold many homes. A lot of people do that. And when were you first made aware of the fact that the defendant was at least claiming that there was an amount that he had incurred debt on by way of a mortgage in excess of what your client in Mexico was supposed to receive in the amount of $3,900?
February the 22nd, something like that.
2/22. And when she came to your office, now we no longer have attorney-client privilege, sir, because she's brought you here as a witness, so you're going to testify to every conversation that you had.
Yes.
You understand that?
Absolutely.
Okay. She came to your office after she found out that the locks were changed.
Actually, I was at home. That was at night.
So when for the first time, sir, did you hear about this money that the defendant was claiming that he was owed?
Mr. Dante called me.
I want you to answer my question.
Yes.
My question is, when she called you the night of the 22nd at your home, did she tell you at that time or soon thereafter that there was a discrepancy that he was alleging with regard to the closing fees?
Not actually, no. No,
she didn't tell you anything. She told you that he just illegally evicted her and changed the locks.
Yes, and at the same time, because of some situations regarding a deal she has on the sale of the property.
Your client knew, as of February 8th, that the defendant was alleging that she owed him money from the closing costs. That's clear. That's what she told me. Now, they had clearly ongoing discussions about this from February 8th or 9th, when the deal closed and she got her money and she's living rent-free. So what I want to know, when did she share with you, not that there was an illegal eviction, not that her pets were in the house, when did she share with you that he was claiming that she owed him money? And I'm not excusing self-help. When did she tell you that? Because she knew it at the beginning. She knew it before she called you.
I have the communication from Mrs. Karen at the time we filed the complaint in the DA office, district attorney office. This is the time when she expressed me the whole facts.
Oh, so she didn't tell you the whole facts when she called you at home on the 22nd?
No, because she was very worried. She was concerned regarding the babies.
Don't tell me that. Okay.
That's it.
Now I got it. So I got what you're dealing with. I understand who I'm dealing with. Okay. On what date did you get your pets back, Miss Heckendorf?
The 22nd.
Okay. What time?
Well, I didn't actually get them. I got them the next day because my friends went and begged for the animals.
Don't tell me what they did.
They gave them and they gave them to my friends.
Stop it, please.
Sit.
Yep.
I just asked you when you got your animals back. So you got your animals back on the same day as he changed the locks on the house. They were given to friends.
Yes.
Is that correct?
Yes.
So they were returned to you the same day because if they were given to your friends at your direction, your friends were your agents.
Yes.
Good.
Only the dogs. He had my cat the next day.
Did you have a cat or is it an outside cat? Is it an outside cat?
An outside cat that lives indoors, and they put the doggy door down so the cat couldn't get out.
Okay.
He told me he had my cat.
Okay. When did you give him the $2,800?
About 5 o'clock on Wednesday, the 23rd.
Is there a writing of the exchange of that money? I'd like to see it. I can't read this.
The plaintiff has a translated version.
Can I see the translated copy, please?
Can I speak?
About what?
About that paper?
Yeah.
He was the one that drew it up. He could tell you, Your Honor.
No. I want this. Did you draw this up?
Can I see it?
Yeah, sure. Kevin, give it to him.
Thank you.
Did you draw that?
Yes, I participated.
What does it tell me?
It's translated.
Don't speak. Do you have the translation of this document?
Yes, I gave it to you, ma'am.
Okay. Okay, number 5, very clear. This is the agreement that Mr. Zarzosa receives from Ms. Heckendorf $2,800 for concept of refund of pending payment. The previous amount is received fully. Therefore, the debt is liquidated. And number 6, the seller, Ms. Karen Heckendorf, grants the broadest waiver derived from the investigation file presented before the district attorney's office. I assume that that was your complaint, and with a file number filed against Mr. Zarzosa by not keeping any legal action present, past or future, derived from the present business.
This is the police report they're talking about.
I don't care what this says, is you've settled all of your disputes with each other. This says you've settled everything that had to be settled. Okay, but what the translation suggests is by this document, each of you understood that you were giving him money. He was not going to follow through with anything that had to do with the criminal complaint or with a criminal complaint against him. You went your own merry way. Am I crazy, or is that what this document says, sir? You are the lawyer.
Yes, it says so.
That's what it says so. So I want to know why you're all here bothering me. You settled everything. You got back your stuff. You got out of your house. You got your personal property. He has a counterclaim for false accusations and loss of wages as a result of whatever. This document says you've resolved everything with each other. So why are you here?
I did not sign that document under usual circumstances. I hadn't had any sleep, and I was coerced. And he said he was going to burn my furniture or he was going to sell it in the year that it would take me to prosecute him under this Mexican contract.
Put it down, sir. The case is over.
If he wanted to
The case
sue
is
me,
over. You're a pretty savvy lady, madam. You had an attorney that you consulted. He was there when this document was signed.
He wasn't on the real estate deal.
He was here
He
when
was
this...
only on this
Goodbye.
deal
We're
in the
done.
middle of the
Case is
night.
dismissed. So is your counterclaim.
This
Bye.
court is adjourned.
this was really a case about Dante taking my animals for hostage and extortion.
I didn't steal anything.
The only reason I agreed to give him $2,800 was because he said he was going to burn or sell my furniture.
I'm gonna enjoy my house. Thank you, Karen.
That lady was never intimidated into anything.
I don't think so either.
She knew she had gotten an extra few bucks at the closing. She knew that she was really living there rent-free, which is really very nice. You buy a property, letting her stay there for almost a month. I have little sympathy for him because he resorted to self-help, went to the house, even though he knew she was still there, and changed the locks. But that document clearly indicated that both parties at some point said, okay, enough. I'm getting out of the house. I'm getting my belongings. My pets are back. Here's your money, and finished. Well, when you make a settlement, you've made a settlement. You don't get to make one settlement in Mexico and another one in California.
Agreed.
That's not the...
Is suing motorist Micaiah Begum for property damage to his house from a car accident.
Court come to order. All rise.
Have a seat, everyone.
Hello, Judge. Case 2157, Davis versus Begum.
Miss Bingham.
Yes, ma'am.
You hit Mr. Davis's house.
This is wall, retaining wall.
Wall.
Yes, ma'am.
You hit his wall.
Yes, ma'am.
With your car.
Yes, ma'am.
It damaged his wall. His wall didn't move. His wall didn't come up on you. And you were at home at the time.
No, ma'am, I was actually away.
Okay, so you didn't see what happened.
Did not visually witness the incident.
Okay.
Just the damage after.
Who did?
There were several neighbors. One of my neighbors called
You don't
me.
just... You have no witnesses here today.
I do not have any witnesses with me today. They could not.
Do you have a police report?
Yes, ma'am, I do.
I'd like to take a look at it. Thank you. Accident happened on September 22nd. Whose car were you driving?
It was my car. My dad bought it for me.
When?
Last year. Sometime.
What kind of car is it?
2012 Nissan Altima.
You have insurance on the car?
I have insurance.
Did you have insurance, and you're going to tell me with whom, because that you can check, on September 22nd of 2022?
Yes, ma'am.
You did?
Yes, ma'am.
With whom?
Direct.
Okay, let me see that you had insurance. Do you have proof that you had insurance on the car?
Well, I have the policy.
Were you current on payments for the policy?
Yes, ma'am.
Okay, so you had insurance. I'm just wondering why your insurance didn't cover this accident. No. What time did you hit his wall on the 22nd?
It was around 4:30, 4:45-ish.
In the afternoon?
Yes, ma'am.
Where were you going?
I was on the way to pick up my uncle to go to my son's football game.
Okay, so Miss Bingham, tell me what happened.
I was getting off the interstate. I turned right. I was coming up to the light. As I was going to the light, I never seen the car.
Go to the chart and explain it to me.
Okay, so this is 28th. I got up the interstate. This is me driving straight to the light. As I was going straight, just how it happened, a car comes out from over here, Haley Park. It hits me. It caused me to go left, but I was in this lane. I was in this lane. It was going to cause me to go left and hit the cars in these lanes. So I turned right, and I ended up in his yard to avoid a collision.
Do you have photographs of the rear damage to your car?
It's right here, but you can't see. I guess they cropped out most of it.
I want to see the damage to the right
If I may.
driver's side. Yes.
I have some photos that might be helpful.
I'd like to see them.
These are the car, and these are other damages as well.
So it appears that someone hit her car on the driver's rear panel.
Yes, ma'am.
And took off.
Yes, ma'am.
Do you own this home, sir?
Yes, ma'am, I do.
And there's no question that you swerved in and damaged his property?
Yes, ma'am.
Okay. Did you try to contact her insurance company?
I did.
You went home, you were called, came from wherever you were, from work, you came home, you took a look at it. Car was still there when you got home?
No, ma'am. The car was removed. My neighbor was able to put me on the phone with Makia and the police officer, so I was able to get that information. Immediately, when returning home, I reached out to submit the photos that I had taken myself and submit the police report after obtaining it. It took, quite a considerable amount of time to get back with me, but when I reached out again to understand the status, they, said that she's not liable and they were not going to stand behind it.
Can I see what they sent to you? Did they send something to you?
They did send a letter.
I'd like to see it.
I do not have that letter with me, but I actually called to speak with them.
You said they sent you a letter.
Yes, ma'am.
And where is it?
I don't have the letter. It was a denial letter.
That said it was not her fault.
It did not say it was her fault, but they said they could not submit the claim due to, I guess, whatever insurance she had, whatever coverage she had, the amount of coverage.
Oh, no, that's a different story. You see, that's why I need the letter.
Okay.
Either they said that they're denying the claim because it wasn't her fault, or they denied the claim because she had no insurance to cover it.
The letter also indicated, of course, reaching out to the company to speak and discuss it further. So when I did reach out to the point of contact on the letter to understand why they weren't covering it, the amount of coverage that she had did not cover, I guess, property damage. And that was an argument between me and the company. And
well, how much did it cover?
They did not specify.
Oh, well, that's...
They simply denied it and pushed it away and actually hung up on me. So there's no denying the car's there, right?
Yes.
No denying the accident.
No, I do understand you. Do you have homeowner's insurance?
I do have homeowner's insurance.
Did you put it in through your homeowner's insurance?
Consulted homeowner's insurance, and they suggested that I work this out, me personally, instead of taking the hit on my homeowner's insurance as a victim of this accident. So I didn't see that necessary.
Well, Mr. Davis, I sort of disagree with you, sir. And usually that's not the position I take. But if I am to believe Miss Bingham, and based upon the evidence that you presented to me, it clearly demonstrates that she was hit. Her vehicle was a victim of a hit and run. Her vehicle was hit, which caused this accident. There is no indication anywhere in the police reports that she was speeding, that she went through a light.
Based on her own testimony, she swerved in my direction to avoid hitting other cars.
Well, wouldn't that be smart? If her insurance didn't cover it, your homeowners will cover it.
My homeowners covers that, and that's a penalty for me, and I'm a victim here.
So is she.
Crossed over.
Just a second. So is she. She can't find the other driver. I mean, it would be different.
That's her responsibility.
No, sir.
And later today.
We would like the 2 kayaks back.
Correct.
And when did you begin storing them at the defendant's?
I brought them over the next day after I bought them.
Okay, you acknowledge the fact that the plaintiff, who was then your friend, brought them over for you to store. You're not friends anymore. She wants them back. Why not?
Jimmy Davis, claims motorist Micaiah Bigham owes for damage to his house after Micaiah crashed into his yard.
That sounds smart.
It was
She didn't want to hit oncoming traffic coming from the other direction.
It was not oncoming traffic. She was in the same lane with the traffic.
If I am to believe her, and your evidence showing that her car was hit in the rear on the driver's side, so I have no reason to doubt her. There was no issue of drugs or alcohol involved. You weren't issued a citation, I assume?
No, ma'am.
No. Then if her insurance didn't cover it, your homeowners will cover it.
Sure.
And you should go through your homeowners.
My homeowners covers that, and that's a penalty for me, and I'm a victim here.
So is she.
Crossed over.
Just a second. So is she.
I understand.
If I am to believe her, and I believe her, so is she.
I understand.
But what I think you have to do is go through your homeowners, not Miss Bingham. She can't find the other driver. I mean, it would be different.
That's her responsibility.
No, sir. She is a victim of a hit and run. She has no way, unless it comes out of her pocket, of compensating you. She has no way, unless it's out of her pocket, of compensating you. She has insurance. You have no evidence to give me today as to why her insurance made a decision that they weren't responsible. You don't have that with you today, and it could very well be, as her insurance company determined, that this accident, while tragic, was not her fault. She was, in fact, a victim of a hit and run. You were a byproduct of that. So I'm telling you, go to your homeowners.
Well, let me understand correctly here.
What I'm telling you is use your homeowners. That's what I would do.
That's you. I mean, that's a lot of other people would have a different decision. A lot of other people would bring it to small claims court and try to dispute that, and that's what...
Well, that's what you're doing, and I'm telling you that you should use your homeowner's insurance because that's what it's for.
Typically with car insurance, there's property coverage.
You don't have... Sir, I'm not accepting your hearsay. You have to prove your case to me. You see, that's your burden. You have to prove your case. I have now made a decision that the accident was not caused by her. She was not
caused by her deciding to swerve into my property.
Are you trying to talk over me?
Just adding a little extra context to it.
It was not caused by substance abuse. It was not caused by speeding. There was no violation given to her. And according to you, she had insurance. So it's up to you to show me why
her insurance
no, not her policy, why you were told her insurance didn't cover it. You don't have that here. In the event that you give me a letter and the letter said she has liability for a certain amount, but it's not the $5,000 that you're alleging that it will cost to redo this. She only had $2,500. Well, then I would say to you, her insurance should kick in the $2,500, and I'm going to give you the other $2,500. You shouldn't be out of pocket. I would do that. If she determines to underinsure her liability so that she pays less in insurance, then that's on her.
The insurance company wouldn't disclose all of that to me.
They sent you a letter, and you don't have it.
A denial letter, and to reach out to them.
That's what you're telling me. That's hearsay, sir.
Okay.
That's hearsay. It's not hearsay if you bring it in to show it to me.
Understood.
So what I'm telling you is this is an incident where, in my judgment, you have two innocent people who were both victims of an irresponsible driver. And if her insurance company, for some reason, and I don't know what it is, that's for her to take up with her insurance company. I don't know whether she's underinsured or whether they determined, after looking at the same things that I determined, that the accident wasn't her fault. So you can't tell me what they wrote because you didn't bring that letter. And we're talking about something that you got a month ago.
Understood.
Okay, good. Then you go through your homeowners because your case is dismissed. We're done.
This court is adjourned.
The defendant says she chose to drive into my house instead of hitting another car. Both are equally as dangerous, and that cost me.
I didn't want to hit 5 or 6 other cars. So I just did what I thought was best.
You know, I found out because it's a very public street. Many people know that community, so people reached out.
It was just everything happened so fast. I can't explain the image. It was just like, I'm stuck. You know, my car just got stuck, and I was just like, hey, I'm just glad I didn't hurt anybody else.
Because they saw that it was a very horrible accident.
That's all. I was happy I was still here. Not the car, not the house, me. I'm glad I'm still here to go home my son.
No, the plaintiff really hurt himself with those photos of the defendant's car, and he didn't even notice. I don't think he even notices still. But she had no proof in front of her, no papers, no photos of what her car looked like, so she would have no way of showing that the accident was not her fault. But he proved that the accident was not her fault based on the photos of the car and just the situation in which her car got hit. But that's the reason that people have insurance. So I agreed with your sentiment about use it. That's its entire purpose. And I think that if he would have come in here and said, okay, I will put it through insurance, but I have a $5,000 deductible, I felt like you might have been more inclined to give him a portion of that, since neither of them were really at fault. They were both victims of a hit and run. But I would have respected that more if he had chosen to use his own homeowner's insurance as opposed to going after another victim. She wasn't at fault, and he knew that.
She really wasn't at fault. Yeah. She really wasn't at fault. And as we discussed a moment ago, the suggestion that she should have gone into the to the left where there was an oncoming traffic rather than veering to the right and hit something that was a stationary object.
It was definitely the safer option. And in that second moment, she was lucky that she made that decision. You never know. Someone else could have lost their life.
Right.
Case 2153, Fawless versus Mixedbot. All parties, please step forward.
Elizabeth Fawless is suing her former friend, Christy Masenbach, for 2 kayaks and an assault.
Miss Fawless, it is your claim you and the defendant were friends, been friends for a while.
Yes.
Your allegations are twofold. First, you say that the defendant assaulted you after a party.
Yes.
You weren't injured as a result of that assault. You didn't seek medical attention, but you said you had some scratches and that she hit you.
Yes.
Okay.
So she was on top of me. I was scratching, hitting, pulling, trying to just get away. I don't think she really remembers everything, and it just happened so fast, but I was finally able to leave and get out the home with my daughter safely.
Okay, bad behavior.
Okay, great.
Bad behavior?
Elizabeth Fawless claims her former friend, Christy Masenbach, owes for 2 kayaks and an assault.
There was no medical treatment. There was some drinking that went on that night.
Yes.
But the thrust of your complaint is that you gave the defendant 2 kayaks that you had purchased.
Correct.
Because the defendant has a piece of property and you didn't have a place to store them, and you asked if you could store them at the defendant's home.
Correct.
She said yes. You're no longer friends after this kerfuffle that took place after a party, and you would like the 2 kayaks back.
Correct.
When did you purchase them?
I bought them on April 29, 2020.
From whom?
This lady and her mother were selling them on Facebook Marketplace. They were moving out of state, and her mom couldn't take them with her. So I have the messages of those 2, but I bought them on Facebook.
And how much did you pay?
$320, or $350, sorry.
For both of them or each?
For both of them.
And when did you begin storing them at the defendant's?
I brought them over the next day after I bought them because I live in an upstairs apartment. I had nowhere to keep them. So she has a house that she lives in, so it was a better situation for them.
Where are you living now?
I still live in an upstairs apartment.
Where are you going to put the kayaks?
I was planning on storage or maybe find a family member who has a home to take them to. But to basically probably buy a storage.
That's pretty expensive to keep them in storage. If you paid $350 for the 2 of them 2 years ago. Have you used them in 2 years?
I bought them this year, this April 2022.
Oh, 2022.
Sorry, yeah, 22.
Okay. Have you used them?
Yeah, I use them often with my daughter. She's 5 and autistic.
Have you used them with the defendant?
No.
Have you used the kayaks?
Personally, I have not yet. I haven't had the chance to.
Just a sec, you have not?
I have not yet, no.
Okay, you acknowledge the fact that the plaintiff, who was then your friend, brought them over for you to store. You're not friends anymore. She wants them back. Why not?
So I would like to kind of go back to the beginning where like the assault happens, just so that you can kind of understand.
I'll get to this.
Okay.
The assault is not the important part of this case.
Okay. So the kayaks, originally, it was a deal that if I was to keep them at my house, that we could both use them. When she wanted them back, I just didn't necessarily feel like that was fair because the original agreement was that they were kind of almost both ours. I just didn't have the opportunity to use them yet.
Okay. All right, well, now you're not friends anymore. Now she wants them back. So she's going to pick up the kayaks within 5 days. If you don't pick them up within 5 days, you're out of luck. Do you understand?
I understand.
Okay, good. So within 5 days from today's date, we'll prepare an order. You can pick up the kayaks. Now, you want to proceed with the assault part of your case?
Yes.
Okay. Show me pictures of what the injuries were that you sustained.
I don't have any photos. I had a different phone at the time, and...
Just a second, so you don't have any photos. Do you have any medical reports?
I don't.
Okay. This alleged assault happened on what date?
It was August 17th, 2022.
Were you both out that night, or were you having a party in a house?
So what happened was her girlfriend had cheated on her, and they broke up, and she invited me and a couple other friends to the home where we were there. My daughter was also there, where we were hanging out, we were talking, trying to have a good time because she was having such a bad time. And I ended up falling asleep at some point. I went to go sleep with my daughter in the room. Everybody had left maybe around 12 a.m. And she came into the room wanting to talk, wanting someone to be there with her. But I was asleep. I'm not a very happy person to be woken up to. So I told her no, like we'll talk in the morning. She wasn't okay with that. She started getting mad, so she started getting upset, and my daughter was next to me, so I was like, well, then I'm gonna leave. And so I tried to walk out. She grabbed me, she threw me to the ground. She's stronger than me, so she was on top of me. I was just scratching, hitting, pulling, trying to just get away. My daughter was screaming and crying. She's autistic, so she doesn't really understand what was going on, but she was highly upset. She was screaming no. And I was eventually able to get.
ये दोस्तों हम आपको दिखाते हैं हम जा रहे हैं ये चलो इसमें आज हम आपको जाके दिखाते हैं कि हम किधर जा रहे हैं हमारे साथ जुड़े रहिए इस व्लॉग में जा रहा है तस्वीर में आइए चलते हैं हम आपको दिखाते हैं भाईजान बहुत ही प्यारा व्यू आ रहा है
इस प्रोजेक्ट की तरफ से